Assalamu alaikum everyone, and thank you for joining us today. We're really excited to see all of you, some familiar faces and some unfamiliar faces, and I hope that you will join us for some of our future programs as well. We are very excited to be running this Islamic will writing seminar and have two excellent speakers who are going to give us their insights on the topic. So we have we should have Shaykh Imranali Panjwani and Zahra Kanani, who will be joining us in a moment. I just want to start with a little bit of an intro on SICM, so you know what we do. If we can have the slide which shows us our programs, then you can see some of the regular activities we do, and if that's of interest to you. It's nice to see so many people, and it would be really lovely to see you in future events as well. So this is a list of our upcoming events. So these are our, sorry, I'll move out of the way. These are our Friday events, our Salam talks, and you can see the kind of variety of speakers we have, both religious and academic and spiritual. So upcoming ones are, for example, Baroness Wasi speaking on her new book, Muslims Don't Matter. We have community members speaking. We have people speaking about their new books. So, for example, Nafis Musaddiq Ahmed speaking on his new book, The Alt-Right, The Network War to Destroy the West from Within. So we've got a great range of events happening on Fridays, but we also have regular events every day of the week. So you can see, for example, our kind of regular diary is very full. On Mondays, we have Mums and Tots and Ladies Pilates. On Tuesday, we have ladies yoga and ladies exercise classes. Wednesday, we have karate and taekwondo for children. Thursday, we have health classes, and Dua Kamal and Surah Yasin. Friday are the Salam talks, which you saw earlier. On Saturday, we have Women's Walking Club and SICM tuition. And on Sunday, we have tafsir classes and Soul Kitchen and Husseini Madrasa. So we've got a full kind of regular suite of events in addition to our Ramadan programs and our Muharram programs and the kind of birth and death anniversaries of the A'imma. So it would be really lovely to see all of you join us for kind of other events as well. And obviously, if you want any more information on any of these events, you can go to our website, www.sicm.org.uk. You can also join our mailing list via the website, I'm pretty sure. And also, we are building the Salam Center, which if you come out and turn right, you'll be able to see kind of a very nice view of. And we're kind of in the process, and we're looking for donations as well as volunteers. So please do consider supporting us in this kind of really exciting venture going forward. So that's a little bit about what we do, and we really hope that we'll see some of you or all of you join us for future programs as well. Before we start, can I just go through a little bit of housekeeping? So the toilets are on the left over there, so my left, where Afzal is standing. And the exits are at the back and on this side as well. So if there is an emergency, please make your way to the exits. As I said earlier, please make sure that you are kind of filling the gaps in between the seating. So if there are gaps, please make sure that you're kind of scooting over. We have a full event today, and we want to try and get as many people in as possible. And please, can I request that you put your phones on silent or vibrate, so that we can all enjoy the event without distraction. So in terms of the format of the event today, as I said, we've got two excellent speakers who will be speaking to us. It's going to start with the recitation of the Holy Quran from Sister Mandana. We're then going to have Shaykh Imranali starting us off. And he's going to speak for about 30 minutes and give us his insights on will writing from an Islamic perspective. And then we will have Zahra Kanani, and I'll introduce both speakers, and we'll have Zahra Kanani speaking in two parts. So she'll start off her first part, which will be about 45 minutes, We'll then take a small, short break of about 20 minutes and have a bit of light dinner, which we will provide. And then we'll come back to Zahra Kanani to have her second part, which will be about 45 minutes as well. And then at the end, you will have the chance to ask questions, so please do note them down, keep them in mind, and we will have our Q&A sessions with both speakers at the end at around 7:30. So a packed event, but I hope you enjoy it. We're very excited to have you, and we're very excited to have the speakers as well. So without further ado, I will start by asking Sister Mandana to come up and recite some of the Holy Quran.
اللهم صل على محمد وآل محمد. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين، فإن كن نساء فوق 2 فلهن ثلثا ما ترك، وإن كانت واحدة فلها النصف، ولأبويه لكل واحد منهما السدس مما ترك إن كان له ولد، فإن لم يكن له ولد وورثه أبواه فلأمه الثلث، فإن كان له إخوة فلأمه السدس من بعد وصية يوصي بها أو دين. آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا، فريضة من الله، إن الله كان عليما حكيما. ولكم نصف ما ترك أزواجكم إن لم يكن لهن ولد، فإن كان لهن ولد فلكم الربع مما ترك من بعد وصية يوصين بها أو دين، ولهن الربع مما تركتم إن لم يكن لكم ولد، فإن كان لكم ولد فلهن الثمن مما تركتم من بعد وصية توصون بها أو دين. وإن كان رجل يورث كلالة أو امرأة وله أخ أو أخت فلكل واحد منهما السدس، فإن كانوا أكثر من ذلك فهم شركاء في الثلث من بعد وصية يوصى بها أو دين غير مضار، وصية من الله، والله عليم حليم. تلك حدود الله، ومن يطع الله ورسوله يدخله جنات تجري من تحتها الأنهار خالدين فيها، وذلك الفوز العظيم. ومن يعص الله ورسوله ويتعد حدوده يدخله نارا خالدا فيها وله عذاب مهين. صدق الله العلي العظيم.
Ahsant. Thank you so much for that very beautiful recitation, Ahsant. We will now move on to the main part of the program, which is what you've all been waiting for. So I will introduce both speakers, and then we'll get started. So we're very, very privileged and excited to have our two speakers speaking to us today. So we've got Zahra Kanani, as I mentioned, and Shaykh Imranali Panjwani. So Zahra Kanani is a specialist in wills and tax planning. She has a varied caseload of general private client work, such as powers of attorney, probate and administration of estates, with a particular focus on cross-border estates and those which include business assets. Zahra has been a solicitor for the last 15 years. She trained and qualified into the private client department of a well-known firm in the west of London. After a stint in a regional firm, she is a legal director at Howard Kennedy LLP, a full-service law firm based in central London. She has delivered presentations on this topic at many Jamaats across the UK, and is an active member of Haydari, which is the South London Jamaat. And in her spare time, you will find her teaching at the Haydari Madrasa, taking part in other Jamaat activities, and practicing her culinary skills. So an excellent speaker for us today. And then Dr. Imranali Panjwani is a senior lecturer in law at Anglia Ruskin University and head and founder of Diverse Legal Consulting, a consultancy specializing in country expert reports for MENA asylum seekers. He completed his legal studies at the University of Sheffield and University of Law, and thereafter he pursued Islamic seminary studies at the Al-Mahdi Institute, Birmingham, and postdoctoral research at Jamiat al-Mustafa in Mashhad. He obtained his PhD in theology and religious studies from King's College London and has lived and worked in the UK, the Middle East, and Australia. His interests lie in Quranic exegesis, Islamic and Western jurisprudence, human rights, mysticism, philosophy, and education. So, as I said, we're very privileged to have both speakers, but we're just waiting for Dr. Panjwani to arrive. He should be here in the next 10 minutes. So in the meantime, before the speakers get started, we're going to have Dr. Imranali speaking to us about the Salam Center and where we're at with our building project. So I'm really, I know that's the bit you've all been waiting for. Dr. Imranali, if you could come up and speak to us a little bit about the Salam Center while we wait for Shaykh Imranali to join us. Thank you very much. Do you want an intro? Ooh. Okay, so I'm going to wing this one. Dr. Imranali has been a member of this community for 35, 40 years plus. He is a GP in the local area and obviously an active member of this community, and has been tirelessly working on making sure the Salam Center becomes a reality. I remember for when I was about 12 years old, him starting working on this. So I won't tell you how old I am, but it's quite a long time. So very, a very integral part of our community and a very hardworking member of the Salam Center team. So very honored to have him speak to us about it.
My sisters, my brothers, my seniors say, Jafar, you should be sitting here in the front, please. No, I insist that you sit here. No, I'm
making sure that everybody is in a good position.
Say Jafar, I'm insisting that you come and sit here. Please respect me.
I was scared you were going to give me the microphone.
I've just got the chance. Please allow me. So for those of you who do not know, Sayyid Jafar is the son of late Sayyid Professor Ayatullah Fadl Milani. And alhamdulillah, the relationship that we have with Sayyid Fadil Milani, we have continued our relationship with Sayyid Jafar. And inshallah together, Sayyid Jafar has been a great support for the project. Inshallah, we'll finish the project together. So, you can't hear you? I'm so sorry. Okay, any better, Munira? Okay, so my apologies for that. So sisters and brothers, most of you know what's been happening next door. Believe me, Iqbal and myself were under 50 when we started this project. I'll let you guess how old we have reached now. But inshallah we'll finish it before we get 6 foot under. Inshallah we will. The thinking game started 20 years ago. What can we do to give back to the community that has nurtured us? Essentially, that's what we want to do. And how can we actually tell the wider world what our strong madhab is interpreted by Ahlul Bayt alayhi salam? How can we actually share it with the wider community? And that's the 2 key principles here, to try and get the wider community involved, to open the doors for the wider community. You are able to, so how am I going to move the slides? I've just prepared the slides to take with me to Kenya. I'm traveling day after tomorrow, so I could probably use it. I mean, you caught me on the hop. Okay, so most of you know what the building looks like. Believe me, this is not a computer image. This is the building as it is. This is the building if it was moving, but it doesn't. Oh, yes, it does. Okay, these are the actual pictures of the building. Oh, come on. Okay, how do we move it quickly? I don't need to tell you where North Hera is. I don't need to tell you what the buildings look like before, what Mahfil Ali original North Hera Assembly halls look like. We have demolished 2 houses, 2 more houses to demolish. The black mark there here is where the porter cabin is at the moment, and we'll finally be demolishing the other 2 buildings as well. Sajad, help me. Okay, so this is on the left is the north block that we already built. The south block will be built by demolishing this porter cabin and the 2 houses over there, 37 and 39 Gloucester Road, and then we'll have the south block there as well, which matches. These are all the facilities. I'm not going to read them out. You can. Oops, what happened? You're too fast for me, Sajad. These are all the facilities. For those of you who have not been next door, I urge you to try and let me organize that for you. Just give me a call anytime, and I mean it, anytime. I'll take you on a personal tour. You must look at the basement. Sayyid Jafar came 2 weeks ago with his family, and I'm sure he will agree with me that they were really surprised with the vastness of the space there, particularly basement -1 and basement -2. Inshallah, here. So tomorrow morning, Sayyid Jafar, I don't know how many we can. Tomorrow morning, we have Sayyid Jafar has kindly invited the scholars of London, and we've got about 20 people or so coming, and some of the embassy staff from Iraqi embassy as well. But those of you who happen to be free tomorrow morning at 10 o'clock and would like to join the tour, let me know beforehand, so that Hotel Mustafa, so they can increase the order for the Mahambri and Barazi for tomorrow morning. Yeah, but you're welcome. These are the 5 key principles. Again, I'll let you read about it. I mean, it is architecturally, it's a beautiful building, you'll agree. And Allah is beauty. Allah portrays beauty. It is financially self-sustaining. It's an eco-friendly building. It is going to be all-inclusive, and it's going to be financially self-sustaining as far as operational side is concerned. So once we have collected the building, once we have collected the funds to put the final building, and alhamdulillah, we've got no debt so far. Alhamdulillah, we have collected and spent 16 million pounds, believe me. We have got no debt at all. This is what the prayer hall looks like. Ceiling mimics Isfahan design. And this is what the youth center looks like. The ceiling mimics Mughal India. This is what the sports hall ceiling looks like, mimics Masai Tanzanian design. This is what the lecture theater looks like. And for those of you of my age, when we came here in the 60s and the 70s, every semi-detached house here had this floral wallpaper. Do you remember? At that time, I thought horrible. but so that's famous British designer, actually, William Morris. So 50% of the end users today are going to be British born, let's face it. So we have to incorporate the British design as well. So William Morris design, floral design, is being incorporated in the lecture theatre as well. This picture I must show, say, Father Milani Marhum. Did the groundbreaking, participate in the groundbreaking ceremony 2014. I can't play this, otherwise I could have shown you through this. Or all the, so this is the basement, the lecture theatre. This is a basement sports hall. This is the prayer hall. This is the prayer hall with 14 skylights. Okay, this is the first floor Imam Bara. This is, as I said, we have spent and collected £16 million so far. This is where the donations have come from. 1,500 people, trust me, 1,500 individuals and institutions so far have donated something or the other. If you are not one of those 1,500, you have to ask yourself, why am I not part of it? Why haven't I been invited for this? Sorry, Imran is here, so I'll finish it. But you can see the breakdown. I'll let you read where the money has come from. How much more do we need to raise? £16 million again. 4 to 5 million for the construction of the south block, and the rest internal fitting here. I finish. I mean, but obviously we don't need to raise all that money together. We can fit out one floor at a time and move. Isn't it too cramped here? I wish we were next door. And the sooner we get the 1 or 2 floors done, we'll move next door. And for that, we just need £1 million more. Trust me, we already have £1 million in the bank. We have £1 more million more, then I can convince my fellow trustees to sign the contract. So I'm sure you'll help me with that. I think I'm done. I'm done, Sajjad. Just to remind everybody that if you have got your homes money that you want to donate, then say Jafar will tell you that he can arrange to get the receipt from Ayatollah Sistani, Ayatollah Sistani's office. Thank you very much indeed. Assalamu alaikum. Okay, say Jafar wants to say a minute.
Sorry, if you do excuse me, sorry, Dr. Imran. Assalamu alaikum wa rahmatullahi wa barakatuh. Please forgive me, this is an interruption, and I wasn't on the list, but I have to do my duty on behalf of Marhum Father. Imam Rida salawatullah wa salamu alayhi says, لو علم الناس اللهم صل على محمد وآل محمد لو علم الناس محاسن كلامنا لاتبعونا. All it takes is for people to see action. And when the Imam says for people to know about the goodness of our words, the words of Ahlul Bayt alayhim as-salam, is actually talking about the actions, because we are always being told to use action rather than our mouths and tongues in the matter of spreading the news of Ahlul Bayt alayhim as-salam and goodness. So when the Imam is telling us to do this, it's simply, the result is لَوْ عَلِمَ النَّاسِ مَحَاسِنَ كَلَامِنَا لَاتَّبَعُونَ. Automatically, the moment people see action from the followers of Ahlul Bayt, the ones who have realistically picked up that flag and said, I am a Shia, I am a follower of Ahlul Bayt alayhim as-salam in whatever way or sense, whatever you do, then they will automatically be dragged into it. They will automatically feel that they want to be part of this human cycle of being good to everyone, and that is what we expect to see here at the Salam Center. Alhamdulillah, it's done so well. I did, just now that you're talking about age, I did my O-levels here, so it was before GCSE, yes? And but I remember all the hard work at Mahfil from day one. This is 36 years ago, just over 36 years ago. And I'm proud to say that alhamdulillah rabbil alameen, we've been part of this unity, and inshallah keep everybody going forward with the name of Ahlul Bayt alayhim as-salam. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Thank you so much, Shaykh Nazaranko. I understand Shaykh Imranali is now here, so I will ask him to come forward. I've already introduced you, so if that's okay, please welcome him with a salawat ala Muhammad wa ali Muhammad.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم أستغفر الله ربي وأتوب إليه الحمد لله رب العالمين وصلى الله على محمد وآله الطيبين الطاهرين اللهم صل على ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا من لدنك رحمة إنك أنت الوهاب صلوات اللهم صل على Assalamu alaikum, my dear brothers, sisters, scholars, inshallah. Honored to be with all of you. Apologies for my slight delay. I had to attend my daughter's function in a school in Brentwood, so I was just rushing here. So please forgive me, inshallah. So I wanted to take, inshallah, not too long, maybe 25, 30 minutes. Sister Zahra is here, and I think she'll take longer, and she will deal with some of the practical scenarios. As was advertised, and as you can see from the PowerPoint, we are dealing with al-wasiya wal-irth fil fiqh Ja'afri al-Shi'i, okay? Wills and inheritance in Shia Ja'afri jurisprudence. And that might sound like a very simple and obvious title. However, I want to be very honest with you that I did not just look at the general ahkam, or we can say fatawa, from, let's say, Ayatollah Sistani or other respected ulama. I looked at, for example, Fiqh al-Istidlal by Sheikh Bakr Irwani and other fiqh books to give you an understanding of why certain rules are there, what is the structure of the will, why do certain people inherit a particular portion, okay, according to the Quran, and also the importance of the will. So I don't just want to give you some rulings that you can look at yourself on Google, which I still think, yes, I've got some sources there, and I will encourage you to read, but let us try to capture the spirit of the wasiyah and why, inshallah. Is that clear, everybody? Yes? Okay, let's move on. So, you all, I'm sure, have seen this verse, but Allah subhanahu wa ta'ala says in the Quran, Bismillah ar-Rahman ar-Rahim, كُتِبَ عَلَيْكُمْ إِذَا حَضَرَ أَحَدُكُمُ الْمَوْتُ إِن تَرَكَ خَيْرَ الْوَصِيَّةُ لِلْوَالِدَيْنِ وَالْأَقْرَبَيْنِ بِالْمَعْرُوفِ حَقًّا عَلَى الْمُتَّقِينَ. Prescribed for you when death approaches any of you and he leaves behind any property, is that he makes a bequest for his parents and relatives in an honorable manner, bil ma'aruf, an obligation on the God-wary or God-conscious. So, when we're talking about wills, and Sister Zahra will talk about English legislation, ultimately from the, if you like, Islamic perspective, Allah subhanahu wa ta'ala is, if you like, giving us a kind of spiritual and practical advice and warning that death may come at any time. Therefore, be prepared to leave your parents, your relatives, and others things bil ma'aruf, in an honorable manner. So when we say amr bil ma'aruf, enjoining that which is good, honorable, customarily good. That means, please note, customarily. Ma'aruf also means in the sense that what would they need in the current society and context. Okay, I'm slowly breaking it down. I've put an important bullet point, which I don't think is always generally said, but you have the famous Lays al-Bir verse in Surah Al-Baqarah, verse 177, where Allah talks about what righteousness is. Very beautiful verse in the Quran. For time, I haven't put the whole verse because I have other things to share. All I want to say, you can see, is that the prescription of wills appears to be an element of God consciousness, giving wealth to others and using one's intellect. So this verse is coming after Allah's encouragement to righteousness and giving wealth to others, to orphans, to family, etc. Right? Okay. We have a number of ahadith, which you can see there. I don't like to read from PowerPoint, to be very honest with you, but it's quite a complex subject. So you'll see from the first one, this is in Wasa'alu Shia, it is not appropriate for a Muslim to spend a night without having his will under his head, tahta ra'sa. Or man mata bi ghayri wasiya mata mayyata jahiliya. Maytata jahiliya. Whoever dies without a will dies a death of ignorance or of that period. So you can see that the emphasis is very much even amongst the Sunnah to leave a will and to be prepared about a will. That's point one. So I'll just pause here that this is not to scare or anything, but this is for us to kind of have an impetus. Let us jot some things down, even on a paper, even on Microsoft Word. What kind of things are important for our family members and others that we would like to leave according to God's will if death overtakes any one of us. So that's the first prescription from Quran and Ahadith. Is the pace okay, everybody? Yeah. Okay, fine. I'm being quick on some of the slides. Right. So the specific definition in our fiqh books, which I've tried to encapsulate, is in bullet point number 1. It doesn't differ greatly from the definition perhaps within English law, but it's the expression of intent that includes the distribution of one's estate and or covenant instructing a specific task after death. So you will see, I'll deal with the second bullet point, but look at the last bullet point. The will in Islam is divided into tamlikiyya and ahdiyya, which is that the testamentary and the covenantal will. Sorry, the ownership will and the one that is in terms of covenant, where you instruct a particular task or responsibility upon a family member. I'll give you just a brief example. If you're talking about tamlikiyya, that is what you and I would know about leaving parts of your estate to, let's say, your wife or children, parents, relatives, okay? That is when people say the will is divided into 2/3 and 1/3, which I'll go into. That is what we are talking about. It is what you own and then what you divide and what you leave according to the Quran and then according to the choice you have been given in the last third. Everybody clear on that? And I'll show that to you. But this second one, maybe Sister Zahra can also shed light, I don't think is always discussed from my humble experience, which is if you want somebody to look after your child or somebody to take care of your property, somebody to take care of something for you or do something on your behalf, educate this person, look after this property, look after this child, do this kind of tabligh, this kind of project, that is also part of your will. Okay? And that is also important. So we may talk about, I'm using this word carefully because Sister Zahra will also give a definition, legacy. It's not legacy in terms of what you leave in inheritance, but it is legacy in terms of your spiritual and moral legacy for your children and for prosperity. So I'll make a second point here. You will find, I'm sure, that when you attend funerals and you attend a mayyat, and a family member stands up and says, please forgive my father, mother, brother, sister for what they have done, and then they will say, look, we can give sadaqah, we can pray for the marhumin. Yes, I'm sure you've all heard that. But you can take a step before that. And the step before that is to specifically say in the will, I would like X amount of money, or I would like my child, or I want this project to be done by my family to educate people, to build a well, to build an orphanage, to teach, whatever it is. Or please, my dear brother, my uncle, can you please take care of this person and teach him X, Y, and Z. So you can take a step before by specifying that in your will. All right, so this is the division within Islam. Then you have the key terms. There is al-musi, the testator, what is bequeathed, the heir legatee, that is the person that inherits something, and then you have the executor. So the 4 parts of the will are very important. If any of you, myself, whatever, I don't like to say God forbid, I'm saying God wills, I'm being careful here, because whatever God wills is the best. If God wills that I pass away, or I'm going to pass away, before that I am the testator, okay? What I bequeath, what I will, what I write, what I put in that paper is the will. Who my heir and legatee, who they inherit could be children, could be wife, could be parents, okay? And then the executor is the one that takes care of the execution and implementation of my intent and my will and how the estate should be divided. Is that clear, everybody? So you have to have these 4 components in mind, and who you wish to have as somebody that executes your will. Could be 2 people, 3 people, 4 people. There isn't a limit. But my experience tells me at least minimum 2 to share the workload. Could be 3 or 4. Okay? Right. I've already explained this, but you can see these are the definitions for you. You can read them very quickly. I don't want to repeat them. All I want to say that in the second one, you can see certain examples. A will to bury a person in a specific place. That is also a very important one, so that the family knows where this person should be buried. These things can be specified previously, okay? Dispose of the property by building a mosque or Hussainiya, these things, okay? Right. Shall I move on, everybody? Yes? Okay.
Will we get a copy?
Yes, I don't mind, inshallah. I think the organizers can send a copy. I don't? Yes? Okay, no problem, inshallah. Okay, so now I'm sure you all know this, but I want to say it very simply. This is how the will is divided from the Quran, and I'm being very specific. In Surah An-Nisa, from verse 11 to 13, you have this 2/3 division which is fixed by verses of the Quran, which amounts to 66.666%. And then the remaining third is your choice as to how you distribute your estate. And there isn't a restriction on that. But the first 2/3 is fixed. Why and how are they fixed? I have the verses, and I'm not going to go through them, all of them, because it becomes quite a lot, but I have made a table, inshallah, okay? So, for your benefit, this is Surah An-Nisa, verse 11, and you will see how Allah is speaking to us. Yes?
Before you came, we went through all the verses.
Okay, fine. Oh, mashallah, thank you.
Just to save time.
Oh, thank you. So can I skip it then? Yeah. Okay, thank you. Good, alhamdulillah. Okay. Right. What is the spirit of these verses? Why, for example, does Allah specify that blood relatives are prioritized perhaps over others? And you have this distinction of nasab and sabab, blood relationship and a causal relationship such as marriage. So nasab refers to heirs by blood relationships, and those are directly related to the deceased by blood, parents, children, siblings, and then sabab relates essentially through marriage. Now, you'll find an important point here, which is, as I'm going to show you the slides, you will see that even the blood relatives are prioritized within themselves as first degree, second degree, and third degree. So in the first degree, for example, parents and children, and the second could be brothers, sisters, uncles, grandparents, it goes down like that. So there is a hierarchy within the Quran. Number 2 is when it comes to marriage, and wives may often ask this question, where is my share? The spousal share is always there regardless of how much the blood relatives are given. So the spousal share is never ignored, but is specified to an amount which I will demonstrate. And the reason why, you may see from the slides that, okay, why isn't the wife's share or the husband's share, let's say, not as much as another share? Because sabab means that something could break. A marriage could end up in divorce, God forbid. There could be problems, there could be issues. So this is also why there is a kind of distinction between this kind of criteria, okay? So the division of the 2/3 of your will are as follows. That the first degree is your parents and children, as I specified. Because as I said, you will ask, where is the wife? So that's why I addressed it prior, okay? Second degree or husband, your grandparents and siblings, and then your maternal and paternal uncles and aunts and the children. So you'll see from the last bullet point that no one can prevent the spouse from inheriting his or her specified share from the estate of the deceased spouse. So I'm starting off very simply before I go into the percentages, but I'm trying to explain to you the philosophy according to the general and current interpretation of these verses. Now I've said current. There are discussions among scholars about other ways that these ayat can be interpreted. However, from my small knowledge, and I was doing research over the last week, nobody, according to my knowledge, has come up with a particular model or alternative Islamic will based on whatever discussions may be happening within Hawza, within Al-Azhar, within other madaris. But I want to be very honest with you that what I am giving you is according to the general edicts and opinions of Ja'fari fiqh. But discussions about varying shares and in the event, for example, that somebody might need more, yes, discussions like that do take place, but I've not seen, and somebody can correct me, is there an alternative model or an alternative will within the spirit of the Quran and Ahlul Bayt alayhimus salam that is legitimate there as well. So discussions take place, but I've not seen that alternative model. Right. So you will see, I can see that. You will see that I've made this table for you, so you can just have a feeling of how the Quran is specifying the shares. Okay? So you look at the father and the children of the deceased and the basic share. And you will see that the father and mother, that is the parents, are obtaining generally a sixth, 16.66%, but then it varies based on other circumstances, like if the deceased had no child or brother in the case of the mother. Now here, look at the husband and wife. Now, and I'm sure this question will be in your mind. The husband, and then if the wife had a child, it gets a quarter, 25%. If there was no child, 50%. The wife, and if the husband had a child, gets 12.5%. If there was no child, 25%. Now, the reason I posed that question for you earlier, why is there a difference in the shares? Now, if you look at the framework of the Quran, you look at Surah An-Nisa very specifically. You get from verse 1, where Allah says He created us from nafsin wahida, from one soul. It's a very beautiful verse, by the way. If you look at that verse, Allah is starting out from the fact that He's creating the man and the woman from one common essence and source, one soul. Now, there are even still variety of interpretations there. According to some Shia scholars, we have hadith where Hawa comes from the rib of Adam alayhi salam. Okay, the rib from Adam. Other scholars like Allama Tabatabai rahmatullahi alayh reject that in Al-Mizan. They reject it. All right? Now that's fine, and you'll say, okay, what's the reasoning for this? Because you may then ask, if you read, and as Nizar Bhai said, if you read the rest of the verses from verse 1, you will see verses about inheritance, you will see verses about marriage, about looking after orphans. You will see a number of hukuk and rights that Allah discusses. And you will see that Allah is quite specific as to how the inheritance should be, how the orphan should be looked after. Why is Allah specific from verse 2 onwards, whereas from verse 1, Allah is talking about the, I don't like to use the word equality, can be misleading, but that common humanness and the common source of the man and the woman. So please understand that Suratun Nisa is regarded to be generally a Madinan surah. It was a surah revealed in Medina. There is discussion. Is verse 1 Makkan or Madinan? Fine, because Makkan generally are universal verses. I'm giving you this context. Why? Because in that society, men were generally the breadwinners of the society. The responsibility upon them, even till today, is of nafaqah, is that they spend for the wife, and even in other ahadith that we have in Wasail Shia, they spend not only for the wife, but even extended relatives. That is the responsibility of the husband. That was the structure of the Medinan society. Sisters and women today will ask, because this question always comes, why am I only getting 12.5%? Is that a fair question, everybody? Right, you're all saying yes. So I'm preempting the discussion, okay? Why am I only getting 12.5%? Why is a brother gets twice the share of the sister? The simple reason, according to Quran, according to Hadith, is that was the correct framework of the Medinan society. It could not have been any other way. If you and I were living in that society, you would not be asking that question. I guarantee you it. The sisters and the women say, no, of course, because my man or the husband is going out to be a merchant or a hunter or whatever. And so they are providing for the family. So I want to be very clear that we can deal with some of these questions in the end and the philosophy and spirit. But we had myself and Sister Zahra discussion yesterday that I want to be clear and give you what is the current rules and framework, because whilst we can discuss this, as I said, I have not seen an alternative framework that can be proposed that, okay, this is an alternative way to do a will that captures the spirit of the Quran and the Hadith. But I'm being honest with you. I don't want to hide away from any question, all right? Number two. Women today work. Yes? Sister Zahra, mashallah, works, is a lawyer. All of you. And I have seen, and even in other families, that sometimes it is the wife that is actually providing for the family and not the son, by the way. I've seen a number of cases like that, right? So in these cases, there are provisions for the share of the woman to be increased. There are provisions. While some of you may not feel it is always satisfactory, but there are provisions and ways that those shares can be increased. And we had a discussion yesterday. Sister Zahra will, so I'm trying to coordinate the presentations, Sister Zahra will also show you, and this is also there within Sharia, where we're able to give gifts to the wives, to the sisters, to the daughters before death, in order that if they have economic responsibility or that they need more money to survive, those things can be accommodated, inshallah. Have I been clear, everybody? Yes? Salawat, please. I do feel it's important to be honest, by the way, because these questions are on people's minds, and I don't think we should shy away from them, because otherwise I think then we are not looking at the beautiful spirit of Quran and Ahlul Bayt. So I feel we should have the confidence to tackle them. Okay, here are some examples now. These pie charts are not from me, okay? They are from a book which I'm sure you will all know, by Sayyid Muhammad Rizvi, Making an Islamic Will, which has, mashallah, been there for 25 years. And I've only given you a few pie charts, okay? So Allah bless his work. And here, I've given an example to you, just to kind of show you how the will is functioning, right? Here is where the male child gets twice the share of the female child. You can see there very clearly, right? The son is getting twice as the daughter, yes? And the wife is getting 8.33% when the husband is passing away. And then you have this big 1/3 portion there which can be used. So if you go to the next slide, in this 1/3 share, the traditional solution to increasing the wife or daughter's share is to use that 33.3% to put it on the wife and the daughter, okay? That's the first option and solution for you. Everybody clear on that, yes? So that is one thing you can do. However, it does reduce your flexibility and options. Let's say if you want to do a charitable project, or say I want to contribute to Salam Center, for example, right? So all I want to say is that yes, mashallah, you have that 33.3%, but according to the current interpretation, you will then have to play around as to how much to give a near relative and how much you want to do for your own projects and objectives. But that can be accomplished beforehand by perhaps investing or leaving it as a gift or putting it into a trust, which Sister Zahra can explain. Okay. Here, again, is just another example with the husband. You will see again, the husband is getting an increased share there, 16.67%, as I explained, because of the responsibility of providing for the family. All right? Okay, I'll move on. Here is an example of increasing the share of the wife. Okay? So you see here that the wife is getting 12.5% in the first box on the left, but then by adding the 33.3%, she gets 41.66%. That's just an example for you, which I've put in terms of percentages of how a wife can be supported upon the death of a husband. Okay? Shall I move on, everybody? Everything's clear, yes? Okay. Some examples of how to use the third option. Feeding the poor, uplifting the destitute. I've said increasing the share of the relatives, giving to charitable institutions, and the sadaqah, which is perpetual of jariyah, donating to hospitals, schools, and mosques, and building of wells. I think somebody's phone is going. Salawat, please. Okay. Considerations in executing your will. So, you can name as many executors as you like. It can be 2 or 3 or more. And I want to give one caveat here. Over a year ago, I was involved in executing a will with my uncle. It was for his mother-in-law. And I found a few things which I want to share with you, because you may decide who you want to appoint as an executor, whether the men or the respected women, okay? Number 1, executing a will is a lot of work. It is, as I found out. We had to go through bank statements, we had to go through debts, we had to look at accounts in one country and another country. Then we had to make the total number of assets which contributes to the estate, number 1. Number two, she left certain wishes in her will which was not communicated to the other children. And when they were not communicated to the other children, there was a dispute. I'm being very honest with you. And we did our best to resolve it, even with the help of a Jamaat, by the way. And I would say we maybe resolved it 70, 80%. That's the truth I'm giving you. And not only that, we had to say in the end that we have done our best, and we had to record our distribution and division of assets on Zoom in order that, as proof, we had fulfilled our duty in front of Allah subhanahu wa ta'ala. And if anybody complained afterwards, there was proof. So number one is, whoever you're going to appoint, don't just appoint because they're a family member. Appoint that you trust them and they have the intellectual capacity to carry out the work. And I would say appoint 2 or 3 people, by the way, who you feel can work together. So if you feel that these 2 people aren't going to get along, don't do it. Appoint 2 or 3 people that can work together, number one. Number 2, I would also say, be very open about your wishes with the family beforehand. Be just totally transparent and open. I don't think there's any need to hide anything. And if there are mistakes or anything, be honest and share your heart with the family. The whole reason, that's why I gave this distinction of nasab and sabab. Nasab is there because the blood relatives in the end will forgive each other, all right? With sabab, you don't know, it will happen between a husband and wife or something else. So the second thing is, relay your wishes and be honest with the family. Number three, I would humbly say, please make a file now for whatever bills, debts, accounts you have, gifts, prayers you haven't done, siyam, fasting you haven't done. I'll go into that. Make some file, even if it's a 1-page Word document, even if you don't have time, even a 1-page document that, okay, I think my auntie, my mother, my father, brother, I think at least this is a template we can use, and then the rest we can try to figure out. So that's the third thing I would humbly advise, okay? Right, let me move on. Okay. Here are some miscellaneous but important rules according to Ayatollah Sistani. I read his fatwa and I've picked out, because the rest which I have said are from the previous slides. I've picked out the ones which I feel are important. Look at ruling 2736. Hajj that had become obligatory for a deceased person on account of him being able, mustati', to perform it, and the debts and religious dues that are obligatory to pay, such as khums, zakat, and rad al-madhalim, must be paid from the entire estate, even if he or she has not made provision of that in the will. So, whatever debts you have, debts, financial, and what you owe, something unjustly taken, or what you owe to people, anything about khums, zakat, and others are taken out from your estate first. Then, if you like, the inheritance, according to Quran, takes effect for parents and children and wife and the rest. But the first is the debts, okay? That is what's going to be taken out. Interestingly, which some of you may know or not know, any dues pertaining to kafara or nadar, and these appear to be something quite personal based on either sins or a personal act that you undertook, including Hajj that had become obligatory on account of nadar vow, these are paid from the 1/3 of your estate, if they're mentioned in a will. So I just want to mention a point here, that kafara and anything that you promised in front of Allah that you would do, you can put as part of your 1/3. But the main obligations like khums, zakat, and your financial debts are first of all taken out from your estate. Ruling 2794, and I'll make a comment on this.
Can I just clarify?
Yes.
But missed salahs and fasts, is that before the 3rd or after?
So, any missed salah, which is an obligation, would come out from your estate first. Yes, before, because this is an obligation they didn't fulfill. So if you pay somebody for example, to do your qadha salah, that is regarded as something that is wajib. Okay? Right. Sorry?
Part of the debts, basically.
Yes, part of the debts. Yes. Jazakallah, Shaykh. Ruling 2794. A Muslim inherits from a disbeliever, kafir, but a disbeliever does not inherit from a deceased Muslim, even if he is the deceased's father or son. Why have I put that? So today I am noticing a number of interfaith marriages. Okay? So Muslims may marry Christians and Jews. Even I've had vice versa. And this is something, again, that there needs to be greater discussions as how to guide these issues. And you will see the ruling here. And a kafir is somebody, of course, that denies God. Yes? Somebody from Ahlul Kitab or a non-Muslim, how are they categorized? This is an issue. And it's an issue that requires further clarification. And we need more specific guidance as to that, because even if you want to say somebody's from Ahlul Kitab, okay, so you will ask, are they practicing or not? Yes? This is a key question. And if you say, well, yes, I was born a Christian, I was born in this faith, or I'm a Buddhist, or I'm a spiritualist, how do you categorize them? Does it fall under kufr? I wouldn't necessarily say kufr, but again, you have the second problem. The second problem is, what type of aqsam, what categories do you put them in, and how do you identify them? Okay? So the reason I've shared this ruling with you is, according to the current interpretation, let's just be very simple. I would say a kafir and broadly a non-Muslim would not inherit, okay? Broadly, I'm trying to make it simple to you. But I'm not excluding the discussions. And should you ask your maraja, should you ask a respected alim that is conducting ijtihad, whether that particular person can inherit, perhaps there will be a solution based on how Iman is defined and categorized, because there are a variety of different definitions amongst our respected ulama. And I'll give you an example of this. If you look at Ayatollah Nasir Makarim Shirazi, all right? Ayatollah Nasir Makarim Shirazi. He has a different definition of what kafir is, and he doesn't believe that anyone is najis, right, in terms of eating and touching, except if they are the type of kafir that is stubborn and has that aggressive intent against Islam. Yes? That is, and Ayatollah Sani also very similar, right? But if you look, for example, at Ayatollah Sistani or others, you will find a different definition there, okay? And you will therefore find that, let's say, somebody that is a Hindu or somebody that doesn't identify as Ahlul Kitab, then, as you know, there are rulings about touching and wetness and these sorts of things. So the reason I've put that caveat there about consulting a marja or consulting a respected alim of conducting ijtihad may provide a solution in that particular area. All right? So I want to just put that out there. I'm trying to be as balanced as possible. Right, let's move on. I'm nearly finished. The template of an Islamic will. So we had a discussion, myself and Sister Zahra, and Sister Zahra will say this, she's very cautious of me, not me, but generally showing like how a will looks like. I have a link on the last slide that you can access, which gives, in my small view, a nice template of a will according to Islam and Jafri fiqh. That doesn't mean it follows UK law. But from my purposes, I really looked for all of you, and that link can be sent around. That is something you can jot down and fill in. It's very nice. All right? Look at the structure. Statement of your beliefs. I think that is important because you should identify who you are and what you believe in, so the executors know, okay, this is the fiqh and the aqaid that I should follow in executing the will. There is a dua from Zainul Abidin alayhi salam and other imams, Allahumma salli ala Muhammad wa ala Muhammad, which at times can be put at the will to give that sense that, when people are arguing and whatnot, we go back to the Quran and Ahlul Bayt that, look, let us see what is important in executing the will. Eventualities, point number 3, I'm going to end in a few minutes. Eventualities. In the matter of a dispute, if the executors cannot work with each other, you specify the Hakim al-Shar'i or a religious organization to resolve the matter. That could be a Jamaat, that could be Salam Center, that could be a Mujtahid, that could be an Alim, that could be somebody else. So always specify in the event that 2-3 people can't work together, what is your solution? The main body of the will I've already divided, 2/3 and 1/3. Specific bequests, do not forget that, okay? Taking care of a child, leaving property to someone. Your list of debts, zakat and khums. List of qada prayers and fasts. I'll make a small point here. If today you have qada prayers, there is a shortened way you can pray them, all right? And that shortened way, for example, could be not reciting the second surah, okay? Not reciting the second surah. Doing subhanallah once in ruku and in sajda. Not doing subhana rabbil ala wal bihamdi subhanallah. Just doing it once. And doing tashahud and then just saying at the end, assalamu alaikum wa rahmatullahi wa barakatuh. I'm giving an example. So you can shorten your qada prayers just now. But in the event that you cannot fulfill them, yes, please specify them and please don't make it a haraj, a hardship on anyone. Do your best to calculate. Some people do sometimes say, I've got 20 years, but it might be 20 years. Do something realistic and accurate that's not a hardship on someone, okay? The Radul Madalim, repaying or returning rights, try to do it now. Don't wait till later. If you've taken something, if you've not keeping a promise, you owe something, someone, try to fulfill it now, but you can specify that in your will. And I would say most importantly, to be very honest with you, out of all of this is asking for forgiveness. Please specify it in the will. If you need to mention names, please mention names. It's people that you think you have hurt. I've seen, you might disagree with me, but when somebody stands up in the center and says, please forgive my relative, they can say that, but I've seen cases where it doesn't mean anything. I'm being completely honest with you. The person you have hurt is sitting there, okay, he might say, okay, yeah, I forgive you, and he might not say it. So if you specify in the will somebody you have hurt, and that is communicated to that person, it will make a world of difference to the person now, and also it will ease the transition of the soul of that marhum from this life to the next. So specify the names. Don't just leave it to the son or daughter to say, please forgive my father, mother, brother, sister, wife, whatever. Okay? And the final slide, and I will end, is, and inshallah this will be sent around, but you can take a screenshot if you want. I would say out of all of this, the first one is most important. That provides a nice template for you to fill in the boxes, even now today, that you can specify what are part of your assets, what you would leave, according to Sharia. But look at the disclaimer, which I added yesterday, after discussion with Sister Zahra. These sources are only a basic guide and are not to be relied upon for legal or tax purposes. Yes, liability. Okay? Okay, so I will end. Please tell me, have I been clear? Have I taken you through all the main aspects of the will? Okay? Do you have any questions at this stage? I think we'll have a Q&A, but do you have anything that I can very quickly clarify before Sister Zahra comes? Yes. Son.
You mentioned a bit about the Gaza Salah.
Yes.
For Gaza Rosa for someone fasting, it's supposed to be 1 month of fast deliberately missed. Is 30 times 60 makes 1,800 fasts.
Yes.
So in the will, is it that you're doing? For each year missed, you have to have 1,800 fasts.
No. So that's a good question. You can list and calculate that. Is no problem. But there are options, as you know, like feeding poor people, right? Yeah. Giving 1 mud of food and things like that. So you can specify that if this is not possible, please fulfill this option. And if that is not possible, then please give sadaqah to compensate for that. So a figure can be calculated based on this calculation that you gave, that the executors then can use that and take that out from the estate, which I would say is better.
We will have some time at the end.
Okay, no problem.
So no, thank you so much for your question and for responding. I just want to make sure that we have enough time at the end for questions. No, so
inshallah.
if that's okay, thank you so much for your talk. It was really clear, honest, and practical. I learned a lot, so thank you very much, and I'm sure everyone else did. Can we end with a salawat? Thank you so much.
Are you staying or you are picking your daughter?
No, I'm here. Okay. Do you want to use this? Yes. Okay.
Thank you. We'll now have Zahra Kanani. So I introduced her a little bit earlier, and she will be sharing her perspective from a legal and tax perspective on this subject. So please welcome her with a salawat ala Muhammad wa ali Muhammad.
أعوذ بالله السميع العليم من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي لا حول ولا قوة إلا بالله العلي العظيم حسبنا الله ونعم الوكيل ونعم المولى ونعم النصير. Respected Sayyid Ja'far, Shaykh Imran, my elders, brothers, sisters, Assalamu alaikum jami'an wa rahmatullahi wa barakatuh. It truly is an honor to be amongst you all here today, to see some familiar faces, to see some not so familiar faces. And I hope, inshallah, that you all take away something from today's talk, from both what Shaykh Imran has said and from what I'm about to say as well. The title of my talk is up on the slide, Will, Succession and Inheritance Tax. And I want to stress the word at the bottom. This is only an overview. The information that I'm about to present to you today is extensive. Okay, I see a lot of you have got notes here, and I will make the slides available to you. So please focus on what I'm about to say rather than worrying about getting the information down. These will be sent to you tomorrow. I've outlined case studies and examples, so you can look through those at your leisure later, but we'll get through as much as we can today, inshallah. So a few disclaimers, as you know, my profession has already been introduced. So a few disclaimers to set out what I'm about to speak on today. I'm about to talk to you on the law as it applies in England and Wales today. As I go through, I will tease out some of the differences that exist between the law of the land and the law of the Sharia, and where there is a direct conflict between the two. And what you will probably end up taking away from this course, or from this speech, this talk, that it is very difficult to have wills and arrangements that align both with the law and the tax system of this land and the law of the Sharia. And the reason for that is simple. We live in an imperfect society. We are trying to apply divine principles into a system that has been devised by man. And we are accountable to the law of the land. We're accountable first and foremost to Allah subhanahu wa ta'ala. But if I don't write a will in the way that the Sharia prescribes me, I'm not going to be struck with a bolt of lightning. But if I write a will that is contrary to the laws of the land, my family will suffer in tax. So the consequences in some ways are more tangible, shall we say, even though the consequences of Allah are greater. But you understand the point I'm trying to make. We are living in an imperfect system and trying to fit a divine system within that. And that is where the difficulties arise. Wherever we have Sharia points that we need clarification upon, I do consult with the scholars, and Shaykh Imran, I'm very glad to say, has now been added to my list of scholars to approach when I have these difficulties when I'm speaking with clients. The presentation that I'm about to present contains generic content. Okay, the information is already out there in the public domain. I'm assuming a level in the audience of not much knowledge on this particular area, so we're going to build up. I actually have a more advanced presentation of this. Somebody's already asked me, are you going to be covering X, Y, Z? Not in this scenario, because I'm assuming little knowledge, okay? I have a more detailed presentation that we can do at another time that will build upon some of the principles that we learned today that are more complex in nature and that will address more scenarios. But today it's just very generic, but it is confusing, so I do ask for your patience and for your help in getting through this. And my aim is to educate and to raise awareness in this particular area and to explain how important it is. You've already heard from Shaykh Imran the importance of respecting and observing the hudud of Allah subhanahu wa ta'ala, and to make sure that we do our best to observe those. I'm not going to address any personal circumstances, and one of the reasons why I'm so against template wills is because the situations and scenarios of every single person and every single individual are different. I may be diagnosed with an illness and you may be diagnosed with an illness. Okay, there are medical practitioners within the room. My symptoms may be identical to your symptoms, but my doctor will give me a different form of prescription and treatment to you. Why? Because I may have an underlying condition that you know nothing about that affects my illness. So just because somebody has the same situation as you on the face of it, it doesn't mean that the solution that they are given is going to be exactly the same as yours. Okay? Somebody is ill, I am ill, somebody else is ill. The treatment paths are different because the internal workings of the body are different. In the same way, when I'm dealing with families, with individuals, every single individual's family circumstances are different. Even if on the same, everything looks identical. But everybody's family situation is different. Everybody's financial situation and family situation is different. So there's no one-size-fits-all approach here. Okay? So I want to start off with the basic question. I don't want to spend too much time on this because Shaykh Imran has already explained it, and I agree fully with the definition that he has given. The will is a declaration of your wishes in relation to your assets that is intended to take effect upon your death. And it is on your death at that point that the will becomes a legally binding document. At any point until you die, you can revoke and cancel that will. You can sign a new will to replace it, you can rip it up, you can scribble all over it, you can do whatever you want to it, but you can revoke it up until the time that you die, as long as you have the requisite mental ability, capacity to understand what you are doing, okay? The will has to be written in a particular legal form to ensure it is valid as against the law of the land. And I want to draw out one difference here between the Sharia. English law is only concerned with your assets in the will. When somebody passes away, your will is admitted to a process called probate. And if we have time, I will explain what that process is, why it's necessary, and what needs to happen. But for now, when somebody passes away, a will has to go to the UK court to be admitted for probate. Once probate is granted, that will becomes a public document for anyone in the world to see. Now, if I am leaving particular nasiha, particular advice to my children, or if I'm writing out a list of my debts or a list of my people that I have hurt who I want to forgive me, I don't want that to be on public record, necessarily. Yes or no? Some of you may, but most people will not want that information on public record. So when we're looking at a will here, we're talking about the document that governs your assets. We're not talking about the ahdiyah that you mentioned, the one that gives the advice or the recommendations or deals with the aspects of forgiveness. With my clients, I deal with that separately in a side letter of wishes that is a private letter to the family or to the executors, and that letter does not deal with the division of the assets at all. But the physical will that is presented to the UK court is the only document that we need to be worried about today here that I'm talking about that deals with the division of the assets. Is everybody clear with me? That yes, both of these aspects are important, but we deal with them differently. Because I don't necessarily want the entire world going to the probate registry website and for £1.50 being able to download my will and see everything that I have left and given to everybody else. Okay, so there's an element of privacy here that we also need to respect. Why would we write a will from an English law perspective? Number one, to control the distribution of the estate on death. And in English law, we have a fundamental principle called testamentary freedom. That means that I have the freedom to do whatever I want in my will with very few restrictions. Sharia is a system of what we call forced heirship. It is a system under which you are obligated to give a certain portion of your estate to other people. You have no control over that, and that is the 2/3 that Shaykh Imran was speaking about. Under English law, none of that exists. I have the ability to give 100% of my estate to absolutely whoever I want. And this is a fundamental principle of English law. And whenever there are disputes about the provisions of wills, when a dispute goes before a judge or before a court, this is the first principle the judge will always come back to. That whatever that testator has written in their will, unless there is a good reason to go against it, we will respect it. Because English law has this principle of testamentary freedom. Number two, choice of executors. And Shaykh Imran made a great point here, which I discuss with all of my clients. Some of you in this room, I've been through that process with you, and I've had these discussions with you as to who to choose as your executors. And I'll just make a point here that I was speaking with a client earlier this week, and he said, I want to appoint my brother as my executioner. And I you know, for about 10 seconds, I had to realize what he meant. Well, he meant executor, but he'd got the terminology incorrect. So yes, absolutely, you will need to choose people that can work together, people that have the intellectual ability to be able to carry out the task that is at hand. And this is why a lot of the time people who are appointed as executors, they find the work too onerous, they find the work too difficult, they find the work too burdensome, which is why they then come to somebody like me and say, can you do all the underlying paperwork, can you do all the underlying groundwork, and we will sign whatever we need to do, okay? Under English law, you can have no more than 4 executors. 4 is the maximum that you can have. And again, there are no restrictions as to who you can appoint. As Shaykh Imran pointed out, under our fiqh, they must be Muslim. Okay, I believe there are no restrictions on women either. I think some of the Ahl Sunnah have restrictions upon women acting as executors, but our fiqh has no restriction upon women acting as executors. So you are welcome to appoint your wives or your daughters or your sisters as your executors. But again, you have to appoint people that get on with each other, that are familiar with the processes and the practicalities that need to be taken out, because it is an onerous task. In fact, when I was studying back in university, one of the best pieces of advice that my professor gave me at the time was never become a trustee of anything and never become an executor of anything. And I followed his advice till this day, okay? Because it's a very onerous task to take on. The third reason why you would write a will, and this is going to be the core of my presentation today, to minimize inheritance tax on death. Just a quick sense check of the room. How many of you have heard of inheritance tax? So all of you have heard of it. How many of you know how it operates? Only a few hands, okay? So what we're going to see is how the inheritance tax system of this country, which is, remember, an imperfect man-made system, conflicts with the law of the Sharia. And why sometimes always observing the Sharia can lead to a situation where we might find ourselves in a position of having to pay more tax. And the question is, how do we align these two together? It's not always possible, it's not always easy, but our job is to try and make sure that we fulfill both of these as much as we can. And lastly, administrative convenience. Dealing with the estate of a deceased person becomes much easier when they have a will. When you're going through this process of probate and trying to work out who owns what and who is entitled to what, that process becomes much easier, because if you don't have a will, then the law of the land will decide who gets what. And again, that is in direct contravention to the Sharia, as we'll see in a few moments' time. So the overview of my presentation today are those 7 aspects on the slide. And what I really want to concentrate on is number 6 and number 7. I will go through points 1 to 5 very, very quickly because they are important and we do need to understand them. They will lay the framework and the groundwork for points 6 and 7. But 6 and 7 is where I want to spend the most of my time today. Question: what does your estate include? Okay. Your estate includes everything that you own at the time of your death. So that would include your cash, your personal possessions, jewelry, house contents, personal effects, any property that you may own. So that can be your main home, any investment properties that you may have, commercial use properties that you may have, investments, stocks and shares, ISAs, portfolios, these sorts of things. And what a lot of people don't realize is that if you are a person who is a long-term resident of the UK, and this was an aspect of the law that was just changed about 3 weeks ago, if you are a long-term resident of the UK, which basically means the UK is your permanent home, you've been living in the UK for more than 10 years, any assets that you have outside of the UK are also within your estate for UK inheritance tax. So for a lot of us, people that own property back home, India, Pakistan, UAE, right? Tanzania, East Africa. A lot of people have got properties and assets back home. All of these assets are also part of your estate for tax purposes here. You may need to write separate wills in the different countries, but for tax purposes, they are all part of your estate here. A lot of people think this is just to do with my estate in the UK, but this covers everything. Okay, everybody with me? So if you're a UK long-term resident and you have a property back home in Uganda or Tanzania, or you have, as seems to be the trend nowadays with a lot of people that I see, properties in the UAE, let's say, everybody's investing in the UAE, right? That property is now part of your estate and subject to the laws of UK taxation when you die. Okay, so that's very important. What is not part of your estate? So what cannot be covered by the will? Now remember, there's an important distinction to be drawn here. Just because something is not part of your estate, which means your will can't cover it, it's still part of your estate for tax. Okay, is everybody with me with that distinction? Okay, so for example, a jointly held property that you may own with your spouse or with your child, okay? Because it's owned jointly with you and your child, let's say you have a property, when you die, it passes automatically to that child, right? Just because it passes to them, your will doesn't need to cover it. Because it's a joint property, it automatically goes to them. So it doesn't matter what your will says about the property. The fact that you hold it jointly with your child means it goes to your child. But your share of the value of that property is still subject to tax here in the UK. Okay, that's the distinction. Just because it goes to somebody else automatically and your will doesn't make any mention or reference to it, the value of what you have is still taxed. So here under English law, we have two ways in which property can be held jointly by one or more people. Let's use the example of a husband and wife. That's the most common one. So a husband and wife buy a property, okay? When you're going through the conveyancing process, your solicitor, your conveyancer will ask you, do you want to hold your property as a joint tenancy or a tenancy in common? Have you heard these terms before? Yeah? If you hold your property as a joint tenancy, let's say with your spouse, it means that if you pass away, the property automatically goes to your spouse. It doesn't need to be mentioned in the will that my property goes to my spouse. It's automatic. The law operates automatically to pass that property to your spouse. With me? So most husbands and wives own their properties in this way because it is a way. Now again, that's in direct contravention of the Sharia because the husband only has a specific portion that he can leave his wife. Right? So already the way that we hold property in the UK, right, based on an imperfect man-made system is already in direct contradiction because we're already giving the wife more than she's entitled to. But this is the way that we have to secure our spouses in the event that somebody passes away. So a joint tenancy, husband dies, property automatically goes to wife or vice versa, depending upon the order in which they die. The second alternative to holding a property as a joint tenancy is a tenancy in common. That means that each of you own a specific percentage of that property. It could be 50-50, it could be 70-30, it could be whatever you want. And one of the reasons why people these days, particularly young couples, are choosing to hold their properties even with their spouses as a tenancy in common is that one party may have contributed more to the purchase of the property. Let's say you have a young couple, husband and wife, no children. They're working together. One of them has received an inheritance from a family member and has contributed more to the property. They don't want to hold it 50-50 with that spouse because divorce is at the back of everybody's mind these days. If that couple divorces, she wants to get her money out. She doesn't want to say this is 50-50 with my husband. She can change it later on once they've been married for 10, 15 years and the marriage is established. But in the initial days, he or she will want to say, I've put more money in. If something happens, I want to get it out. Correct? So you are finding more and more young couples these days holding their properties as a tenancy in common to reflect the actual physical cash contribution that they make to the purchase of that property. They still hold it jointly, but there is a document saying that she owns 60% and he owns 40%, and this is why, because she's contributed more. Are you with me? Okay. Now, where you hold a property as a tenancy in common. So let's take this example of the wife having a 60% share and the husband having a 40% share. When that wife dies, that 60% under a tenancy in common doesn't automatically go to the husband. It goes under her will. Whereas in the joint tenancy, remember, it went automatically to this other person. Under the tenancy in common, it goes under her will. So if her will says my 60% is to go to my brother or my parent, that's who it goes to. So you'll end up with a situation where the brother or the parent now has 60% of this property and the husband owns the remaining 40. Everybody with me? Okay. The next asset that doesn't form part of your estate, any insurance or life policy that you have written in trust. Now, many of you will have gone through this process of taking out an insurance policy when you purchase your properties, right? That in the event of somebody dying, there is a pot of money there to be able to pay off the mortgage, let's say. Now, you will usually be advised by the people that are helping you to set this up that write this property into a trust. So when you die, the money doesn't come directly to your spouse or to your children. It goes into a trust. Why? Because if it goes into a trust, it's outside of your estate. And if it's outside of your estate, it can't be taxed. Right? So that money, that insurance policy, a lot of people will also take out life insurance as a way of funding inheritance tax. For young couples, that's a very common way to have a pot of money available to fund inheritance tax. If you write that policy into a trust, it pays out to the trust and is not part of your estate and therefore cannot be taxed. So that money, because you have no control over it, it's not part of your estate, Islamically or legally. Everybody with me? Now the third one is much more controversial, pensions. Okay, some of you will have been aware of the monumentous changes that we had in the budget 3 weeks ago. Yeah, I can see a few nods around the room. Those of you that are in employment, one of the perks and the benefits of your employment might be something we call death in service. Yeah? So right now, my firm, if I die whilst I am employed by my firm will pay out 4 times of my salary to the people that I have chosen, to the people that I have nominated. Why? As a form of insurance. It's an employment perk that a lot of companies offer their employees. Similarly, pensions, right? We all have, those of us that are in employment, we all have workplace pensions that are paid into automatically every month. Some of us may have private pensions. And up until now, pensions were something that if you put the money into, it was free of tax, free of inheritance tax. The government could not touch it if you died. That's all changing from April 2027. Any money that you have in a pension is now going to be subject to 40% tax from April 2027. And I've got an illustration of how this works a bit later on. Okay, so I'll explain how this works. But that pension, even though it's going to be taxed, because I have no control over it, it's not part of my estate. Are you with me? Okay. So I don't want to spend too much time on this, but I want to tease out one difference between the Sharia and what the legal position is, which Shaykh Imran mentioned. So what would you typically include in a will? Okay, so as I said, the instructions, the nasiha, the advice, the requests for forgiveness, the debts, that is something you would put in a separate side letter. But the actual body of the will that deals with the assets and that deals with the practicalities, these are the sorts of things that you would include. You would include burial wishes. But as Shaykh Imran said, make your family aware of these things. Because in our communities, kafan, dafan, ghusl happens almost immediately. So if you have a particular wish and your family are not aware of what you want to happen, that wish may be overlooked. So even though it's sensible to put it in the will, it's also even better to let the family know if you have any particular wishes surrounding the actual operation of the janazah itself, shall we say. The will, you appoint the executors, no more than 4. They all have to be adults, so over the age of 18. Under English law, there is no restriction on who can be an executor as long as they are fully mentally capable of acting. And a lot of people, particularly those people who have complex circumstances, so people who own lots of assets, businesses, shall we say, assets abroad, shall we say, significant value, complex, high-value estates, they may choose to appoint professionals as their executors, solicitors, accountants, to take on that role instead of choosing family members, because a lot of the time, let me be perfectly frank, if the husband is running a business, a lot of the time, unless the wife is involved in the business, she doesn't have a clue what's going on. So she would not be the appropriate person to appoint as an executor to deal with that business because she has no knowledge of the operation of its affairs. So you have to think very practically about who is capable of fulfilling that task and who is the right person to choose. For those of you that have minor children in the room, so children under the age of 18, you have to think about guardians. What happens if you and your spouse both die whilst your children are under 18? God forbid an accident happens. If one parent is surviving, that's okay, but what if both of you go in an accident? You need to have provision for legal guardians. Who is going to be legally responsible for your children? Those guardians need to be able to get on with the executors because the executors will control the money that goes to the guardians to look after the kids. Yeah? So all of these things have to be taken into account. Specific gifts of cash or property. Let's say you want to make a charitable donation to the Salam Center, £5,000 to the Salam Center. Say you want to leave £5,000 to your neighbor. I'm just throwing these figures. You would include those specific wishes within the wish itself, within the will itself. And also, as I've said here, outstanding salah, saum, khums, zakat, sadaqah, radda mazalim as well. One important difference here. Inheritance tax is taxed on the value of your estate when you die, but that value of your estate can be reduced if you have any debts. Shaykh Imran told us that under Islamic law, the outstanding salah, khums are debts of the estate. Under English law, they're not debts. These are just payments I'm making as gifts. So my outstanding salah payments cannot be used to reduce the value of my estate for tax. Yeah.
What if you know the amount
yeah.
beforehand
Mm-hmm.
and you stipulate that within the will?
You can stipulate them in the within the will, but that will still be treated, you can stipulate it, but it's still treated as a payment to X charity or X person to fulfill this obligation. It's not a legal debt. A legal debt is something like a mortgage, an outstanding utility bill, an outstanding credit card bill, something I owe another person. The debt, ironically, the debt that I owe Allah is not treated as a legal debt.
However, I can word it in a way that it is a debt.
You can word it, but it will not legally be counted as a debt. Yeah.
Even if you create a side letter with your brother.
Because it's not a debt. It's not a debt.
No. Your brother gives you a debt. Your brother gives you a debt which he doesn't pay.
That's different. That's a debt. That's a debt in itself. Sorry, I thought we were talking about the religious obligations. Yeah. Yes. So if you owe a debt to another human being, yes, that's fine. That there's a side letter, there's a loan agreement. That's the debt, and that is deductible, and that reduces the value of your estate. What I'm talking about here is the outstanding religious obligation.
What I'm saying is that
To try and create it into a debt. You could, exactly, and I agree with you. I agree with you.
No, it isn't. So for example, even today.
Shall I tell you the way that we deal with it before? I don't want to get bogged down on this point. The way that we deal with it is we deal with it as a payment to charity. We deal with it as a payment to a UK registered charity, so that payment is exempt, so it doesn't affect the tax position. But it's an important point to note that what is a debt for Islamic purposes is not necessarily a debt for legal purposes. They're not counted in the same way. Yeah? And then after those legal debts have been paid off, you distribute the estate. So legal debts would include things like the mortgage, the funeral expenses, the inheritance tax, outstanding utility bills, outstanding debts you owe other people. Only then is the estate then distributed according to the will.
So the funeral debt is a debt?
The funeral debt is a debt. That's treated as a debt, yes. So for example, for a lot of people that are members of burial schemes of Jamaats that have already prepaid in life, that debt is already paid in lifetime, so it's not a debt. But for example, I had a family not so long ago from Stanmore. And they had already had a plan with Hujjat, so Hujjat took care of the expenses, but the family wanted additional services over and above, so the provision of a hearse or a coffin or whatever it may be, and that came to about £2,500. That £2,500 was a debt that we could apply to reduce the value of the estate. But because the funeral plan itself was already prepaid, that's not a debt. Yeah? Everybody with me? Okay. So in order for a will to be legally valid, it has to be made by somebody who is an adult. So somebody who is over the age of 18, and somebody who has the requisite mental capacity to make that will and to understand its effect. Okay? When you make a will, there must be no pressure from anyone else. All too often I have seen situations where a family comes to see me about making a will. The will is for mom and dad, but the son and the daughter are in the room. They're making comments. They're trying to guide the conversation. I have to ask those people to leave the room because at the end of the day, it's mom and dad who are giving me the instructions, not the children. And I have to be, as a professional, in a situation where I am comfortable that these instructions are coming to me from mom and dad without any pressure, at least when I am speaking to them. Okay? A later will always revoke or cancel an earlier will. So let's say I sign a will today on the 26th of April. I change my mind about a few things and I sign a new will on the 1st of May. That 1st of May will now stands and it has cancelled out the 26th of April will. One important thing to note is the marriage, legal marriage, and again, I have to be clear here because I'm still seeing a lot of situations in our communities where people are entering into nikah marriages or mut'a marriages which are not legally registered. So here I'm talking about legal marriages. A legal marriage automatically revokes a will. So let's say I make a will today on the 26th of April. I get married a year later. That marriage has now cancelled out this will, and I am treated, if I don't make a new will, I'm treated as having died without a will. So this is something really important, particularly for the youngsters in the room that have got assets to leave, that are thinking of getting married. What you can do is, if you are engaged, and this will only happen if there is a real person in the picture, you can say, I'm making a will in contemplation of my marriage to Mr. X or Miss X, and this will stand whether or not I get married to Mr. X or Miss X. There has to be a person. I can't just say I'm making this will and no matter who I get married to, this will be valid. The will has to be made in contemplation of marriage to a specific named person. So if you are an engaged couple, yes, and you're earning, you have property to leave, then yes, you would want to make a will in contemplation of your marriage to Mr. or Mrs. X. Everybody with me? But if you don't do that, you make a will and you get married, legally married, later on down the line, that marriage cancels out the will, and if you then die, you're treated as having no will. Divorce doesn't work the same way. If you're divorced and your will names your ex-spouse, they're just treated as being crossed out. So if your will says, I give everything to my spouse, but if my spouse is not there, it goes to my children, and you get divorced, the spouse is just treated as being crossed out and everything would go to your children. What is really important is people that are in that phase of separation. Okay, so if you're separated from your spouse, but you're not divorced, chances are you probably don't want everything to go to your spouse if you were to die in that period before getting divorced. So couples that are separated, it's especially important for them to update their wills, because if you don't, it automatically goes to the spouse if you don't have a will, or a large part goes to the spouse if you don't have a will. The will has to be in writing, and it has to be signed, and it must be signed in the presence of two adult, independent witnesses who must also sign. The witnesses cannot be anybody who benefits under the will. So if you have benefited your daughter, you have benefited your sister, that person cannot be a witness to the will, and their spouse also cannot be a witness to the will. So generally my advice to clients is, have somebody who is completely unconnected to your family to be a witness to your will. In most cases, it's not a problem. The clients will come to the office and me and a colleague will be a witness, and nobody leaves me anything in their wills. So it's not a problem, okay? But there are certain clients where I post the wills out. So I've got a family families in Birmingham or Portsmouth or whoever that I'm working with. So I remember I sent a will out not too long ago to a family in Birmingham. And my letter was very clear. The witnesses have to be completely unconnected to you. Nobody in your family. Get a WhatsApp message. Can it be my sister and her husband? No, uncle. Can it be my son-in-law and my daughter? No, uncle. Who can it be? Uncle, just go to the mosque. Any two people will do. Any two people will do. Okay? I don't know if there are any restrictions under the Sharia upon who can act as witnesses, but generally we have no restriction. Under English law, any two people who are adult and unconnected can be witnesses. If somebody who benefits under the will does act as a witness, that means they forfeit their entitlement. So let's say you leave your house in your will to your daughter, and your daughter or her husband act as a witness, she basically loses the right to that house. The will is still valid, but she loses the right to her entitlement under the will.
So just one thing to add is, if it's a female witness, then the rules of witnessing would apply. So you would have to get 4 female witnesses. So that may cause an issue currently. So as sister said, to go to the mosque and find two uncles.
Practically, it would be two uncles are always the best solution. I think we also have to take a slightly, I think again, approach things in the spirit of the Sharia, because if somebody can only find 2 female witnesses or 1 male and 1 female, we want this will to be legally valid. So I think we can accept that as long as there are 2 adult witnesses there, it is sufficient for the will to be legally valid, and it will be accepted as a declaration under Islamic principles of that person's intentions. I think we have to accept the Sharia in its spirit, as well as the black letter. Pardon? Yes, as long as they're not related to the testator, to the person making the will, that's fine. I've added the final bullet point, remote witnessing via video conference. This was something, you know, when somebody witnesses a will, the two witnesses and the person signing the will, they all have to be in the same room and they all have to see each other sign. Now, during COVID, with social distancing rules, that became more difficult. So the government, for a period of 2 or 3 years, 4 years, introduced this ability to witness via video conferencing facilities. So via Zoom or via Teams or any other WhatsApp, that kind of situation. It was a very complicated way to make things happen, but that has now stopped. That stopped last year, but I've still mentioned it there because there may be some of you in this room who made use of that facility if you were making wills during COVID. Miscellaneous matters. Always make sure that the will, the original will, is accessible on your death. Now, we have a hadith, as we've seen, that the will should be under your pillow. These are all metaphors, okay? This is an idea that the will should be accessible to your executors at the time of your death. Most people, if they have their wills professionally drawn up, they will choose to leave it with their solicitors. And the reason that they do that is because we have facilities that allow for these documents to be kept safely in areas that are fireproof, waterproof, floodproof, whatever it may be. If you keep your will in your home and you have a robbery or you have a fire or something happens, that will can be damaged and it can be destroyed. So most people choose to leave the original in a safer place with the professional that has made it. If you ever want to make an alteration or an amendment to your will, please do not take a pen and scribble all over it because that invalidates the entire document. You have to start again. Or you have to write an addendum to the will called what we call a codicil, an addition to the will if you have any wishes that have changed. Okay, too many people I see, red pen here, black pen here, you've invalidated the whole document. We now need to start again anyway. Okay? Never attach any document to a will, any other document to a will, and we would even go so far as to say, do not even staple your will or paperclip it. Because when the will goes to the UK courts for probate, and if there is an indication that there has been movement to the document, the court will take the view that the will has been tampered with. And remember what I said at the beginning, the court protects the principle of testamentary freedom. If they think that there is an indication that the will has been tampered with, they will invalidate it. So when we are drafting wills professionally for our clients, we strip bind them, or even in my previous firms, we used to sew them in a way that they can't be taken apart, right? So it's really important that these little things, they may be little, but they're very important because you could have a beautiful will that is valid, but if there's paperclip marks on it or a staple mark on it, the court will not accept it as a valid will because it will say, we think this has been tampered with, and if you can't prove it hasn't been tampered with, we will invalidate it, right? When should somebody review their will? So generally when you have a life event, marriage, separation, divorce, if there is a new child born into the family, a death in the family, if there is a change in your financial circumstances, you may one day receive an inheritance from somebody. Your business might do really well, okay? That is an occasion to review your will. Every time there is a change in the type or the rate of taxation, we have just had one of the most monumentous budgets in the history of this country that has changed tax legislation and turned it on its head. I have clients coming to me daily saying we need to now review things because that has been a monumentous budget that has really affected a lot of people, okay? And as a rule of thumb, I will say to my clients every 5 years, even if none of the above have happened in your life, as a rule of thumb, every 5 years, take it out, sit down with your solicitor and say, please explain to me what this does. If you are happy with what you hear, we can put it back under your pillow or put it back in the safe for another 5 years, okay? But if you feel, my wishes are not quite reflected anymore, things have changed, I want to update it, then that's the opportunity that you have to update it. Everybody with me? Okay. I want to mention, yeah.
Sorry, I'm really sorry. I don't mean to interrupt, but we will have time at the end for questions, and we're running quite behind. So I just want to make sure that we do, leave enough time, if that's okay. We will definitely take questions at the end. Thank you.
Just jot it down.
Yeah, write it down, and we'll pass it on. Thank you.
So a will under English law can be challenged by people in certain circumstances, and this is where it's very important to understand these percentages that Shaykh Imran spoke about in Sharia and how they interact here. If there is an indication that the person making the will has been forced by somebody else to write the will in a particular way, the will can be challenged. So for example, I gave you the example, didn't I, of me seeing clients where the children are in the room at the same time, objecting or trying to guide the conversation, okay? You might have a couple who has 4 children, but only 2 are present at that conversation. The other 2 that are not there may raise a challenge and say, well, the 2 that were there had an influence over my parents. Okay, so anybody, if there is an indication that your will has been challenged or that your will has been influenced by somebody around you, that can be a form of challenge. If you have a lack of mental capacity, and which becomes particularly important as people grow older and as we see diseases like dementia, Alzheimer's, Parkinson's on the rise. If there is an indication that you have a lack of capacity to be able to make the will in the way that is legally required, your beneficiaries can challenge the will and say this person didn't know what they were doing. And they would have to bring proof, but that is also a possibility. And the third one is the most important in this situation. A lack of provision for family members and dependents who would expect to inherit from your estate. And I've cited a case here, the case of Kaur. This was a Sikh lady, a Sikh family. The husband died, leaving an estate of about 2 million. He had 4 children, 2 sons, 2 daughters, and a wife who survived him. He left his wife nothing. Nothing. And he left everything to his 2 sons. He didn't even leave his daughters anything. The wife brought an action under a piece of legislation called the Inheritance Provision for Dependents and Family Act 1975, which allows people who would expect to inherit from the estate, usually spouses, minor children, or people who are financially dependent upon the deceased. If those categories of people are not provided for in the will, or not provided adequately in the will, they can raise an objection or a challenge against the will. So this Sikh widow raised a challenge against the will. And what did the court do? The court readjusted the will to give her over half of the estate, because they said that this is what she would have got if they had divorced. They looked at the history of the 66-year of marriage of this couple, and they said that she had played an equal contribution in building the textile business that the family had. And therefore, there was no legitimate reason why the husband, because he was, in his will, he said it very clear, I want my assets to pass down my bloodline, down my male bloodline. Sounds familiar, yeah? The court readjusted it. The court readjusted it and gave her over 1 million. Now, the reason that I make this point is that although all of us are in this situation, we are practicing believers and we understand the hudud and the rights that Allah subhanahu wa ta'ala has set down for us, that still means that there is a possibility that me, as a practitioner, when I'm writing a will and somebody says to me, I'm only going to give my wife 12% or 14% or whatever it may be, I have to raise the possibility and say, do you realize she could make a claim? Just because she's Muslim and she's Shia doesn't mean that she's not going to go to the English courts for recourse. She will. She will. Especially if, as Shaykh Imran said, this was made for a time in Medina. I'm not saying it was made, but this was delivered at a time in Medina where males had responsibility. We're now living in a different era. She may not be able to rely upon her sons to look after her. And I will make one thing very clear here, which is controversial. And I say this every time. Every single family that comes to see me will say, my children will not do that. My children will observe my wishes. They will do exactly what I want. Let me tell you one thing. Nobody is immune from the waswas of shaitan. As Imam al-Sadiq says, حُبُّ الدُّنْيَا رَأْسُ الْخَطِيَةِ. The love of this world is the root of all evil. Whenever there is money involved, I have seen even the families of alims fight. So you have to be precise, and you have to, even when you are observing the Shari'i principles, you have to be aware that there is an opportunity for somebody who feels that they have not been provided for adequately to go to the law of the land and say, I'm demanding what I think is my haqq, even though it may not be your haqq under the eyes of Allah subhanahu wa ta'ala. Do you see the controversial difference that exists here? What's the solution? We'll come to that. We'll come to that. Okay, what happens if I die without a will? Okay, somehow everybody who comes to see me, everybody who comes to see me seems to think that as soon as they write a will, they're going to die almost immediately. Okay, I'm happy to say that the majority of my clients, alhamdulillah, are still alive.
Do you have Israel in your office?
Do I have?
Do you have Israel in your
Unfortunately, yes. But where do they not exist, right? So a lot of people put off this very important act because they sort of feel that it's somehow going to preempt or accelerate their death. Okay? So, quite actually the opposite. Yes, you heard it from Sayyid Jafar, yes? What happens if, under the law of the land, if I die without a will? If I die without a will, under the law of England and Wales, I am known as somebody who is intestate. Okay? And there are three main scenarios in intestacy. Scenario one is if I die and I leave behind a spouse, but I have no children. Scenario two is if I die without a will, I leave behind a spouse and I have children. And scenario three is I die, but I have no spouse. And the law steps in to dictate who receives what in that scenario. And what the law says about who receives my assets in that scenario is in direct contravention to what the Sharia says in terms of percentages. So let's see. Scenario 1A. I die and I leave behind only a spouse and no children. My spouse gets the entire estate. Under Sharia, my parents would also be entitled to a share, but they are not legally entitled to anything. Scenario 2, I leave behind a spouse and children, or any other lineal descendants, so grandchildren. The spouse gets the first slice of the estate up to the value of £322,000. Everything else is then divided into two. The spouse gets one half, the children get one half. Again, under Sharia, in that situation, my parents would also be entitled to inherit, but they get nothing. Scenario 3, what if I die and I leave behind no spouse? Then my wider family exists, and these are in priority order. So if there is even one person in the first bullet point, the people in the second and subsequent bullet points do not inherit. So if I die without a will and I have no spouse, but I leave behind children or lineal descendants, they get everything. If I die without a spouse and I have no children, then my parents get everything. And then siblings, and then siblings' children, grandparents. And if lastly, I'm in that unfortunate situation where I have no blood family members, the Crown, which is, or the Treasury, Bona Vacantia Division, which is now managed by Prince William, inherits. And I have to say that the assets that go to Bona Vacantia, the assets where they are not able to identify any heirs that go to the Crown, to be fair, the Treasury use that for charitable purposes. But the point is that you want to be able to have a direction and dictate where charity in your name is used, right? So none of these scenarios are ideal. They are all in direct contravention of the Sharia. So if I die in the UK without a will, it doesn't matter what the Sharia says. This is what the law will say happens to the assets that I leave behind. I just want to finish this one slide, and then we'll break for a dinner, because I think we all need it. We're now coming to the crux of my presentation, which is inheritance tax. Okay? Inheritance tax. So if you think that what we've talked about up until now, it's difficult to reconcile with the Sharia, wait till you see what now happens when we bring tax into it. Okay? Inheritance tax is the tax that is paid on somebody's estate when they die. Just to give you an idea of the figures, last year the Treasury collected about 7.5 billion from inheritance tax. Now that's nothing, because income tax grants them, over 150 billion. Even more, I believe. More than that, yeah, more than about 200, I believe. 200 billion. So in the ocean of tax receipts, this is a very small portion. And you may have seen some of the commentary and the political commentary when the election was happening and the budget was happening, and there was all of this discussion about Rishi Sunak and his wife and her filing position. You will have seen a lot of commentary about the government wanting to abolish inheritance tax. That has come up in the last couple of years. No chancellor in their right mind will abolish inheritance tax, because that would be leaving a hole of 7.5 billion. Where are they going to fill it from? Okay, so 7.5 billion in the grand scheme of tax receipts for the government is not much, but it's still something. Yeah, it's still a sizable chunk. Still a sizable chunk. So 7.5 billion was collected by HMRC in 2023, 2024, up from 5.99 billion the year before. So there's been an increase of £1 billion in inheritance tax over the period of a year. Okay. However, having said that, only about 5% of estates in the UK actually pay inheritance tax. And the reason for that is most people make sensible use of the allowances and the exemptions that are available to them. They have proper wills that allow them to make use of these exemptions, and they implement measures in their lifetime legally to reduce the value of their estate. The reason why the majority of people who pay inheritance tax are based in London and the South East are generally because property prices have risen exponentially over the last few years and the rates and the allowances have remained the same. So that has pulled more people, by the government doing nothing, into the inheritance tax net. Okay? I leave you with the final 2 points. Every individual has an inheritance tax threshold allowance of £325,000. To give you an indication, that same threshold in America is 14 million. So very few people pay federal estate tax in the US because the allowances are so high. Here in the UK, we have this allowance of £325,000. The technical term for this, and I'm going to start now using technical language, is the nil rate band. The reason why it's called the nil rate band is if you have assets up to the value of £325,000, they are taxed at 0%, which is why it's called the nil rate band. Okay? And it has been frozen at this level until 2030. It used to rise, not in line with inflation, but it used to rise a little bit every year. Ever since I've started practicing in 2009, it has been frozen at £325,000. And it is still due to be frozen at that level at least until April 2030. Okay? The basic position is that if you die with an estate that is worth more than £325,000, anything above that £325,000 is taxed at 40%. Anything above 325 is taxed at 40%. Okay, and that's a flat rate. It's not a progressive rate that some is taxed at 20, no, flat rate, 40%. How do we mitigate it? How do we reduce the inheritance tax that would be otherwise payable on our estates? Usually by having proper wills that are tax efficient, and also, as I said, lifetime planning. We'll end there because I want to get into some calculations, and I think you all need your kebab rolls before we get into that. So, inshallah, we'll break there.
Thank you so much. Can we give Zahra a loud salawat to say thank you for that very interesting talk?
أعوذ بالله السميع العليم من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم. Thank you all for coming back so promptly, and I hope you are now energized with your kebab rolls to tackle the next part of this session. Okay? So in this part of the session, I'm going to go through how inheritance tax works. And I'm going to build it up case study by case study, example by example. So hopefully by the end of it, you will all understand briefly how this tax works. Okay, this is a very complex tax. I'm only giving you the basic information here today. And as I said, we can always have a follow-up session to go into more specific scenarios and more specific details if we need to. But today is just very much a basic. You'll be amazed, I think, at how complex the basic is. But we're going to be building it up example by example, okay? So the first example that I have here is of two brothers, Hassan and Hussein. And for the purposes of this example, we are assuming that Hassan and Hussein are both single and unmarried individuals with no children. Okay, so your average single person. And we are also assuming in this scenario that they both die before April 2027. And I'll explain why that's important. So Hassan dies, and he leaves behind an estate of £325,000. His house worth £285,000. I'd love to know where in London he lives for have a house of £285,000. But, you know, maybe it's a studio flat, who knows, okay? So Hassan has a house, studio flat, of £285,000, stocks and shares of £20,000, cash of £20,000, pension that he has nominated for somebody to receive, but as we said, prior to April 2027, pensions are not part of the estate, so we ignore that for now. So his total estate is £325,000 allowance, is £325,000. You'll remember I said the nil rate band, the allowance is £325,000. As his estate falls within that value, Hassan's estate pays no tax on his death because he's within that 325,000 limit. Let's contrast to his brother Hussein. Hussein passes away having a house worth 500,000, stocks and shares of 100,000, cash of 50,000. Again, his pension is nominated prior to April 2027 for somebody else, so we ignore that. So his estate is worth 650,000. From that 650,000, we deduct his allowance of 325,000, which leaves us with a net estate or taxable estate of £325,000, and on that his estate pays tax at 40%. So his estate pays tax of £130,000. Now if you look at what Hassan owns, it's what the average person would own, right? Property, cash, it's an average estate. But his estate ends up paying £130,000 in tax. Now, position after April 2027 when we take the pensions into account. So the values of everything else are exactly the same, but for Hassan, I've inserted a pension of £50,000. So his estate now goes up from 325 to 375. We deduct his 325,000 allowance. His net estate is now 50,000. So his tax liability, or his estate's tax liability, is now £20,000 after April 2027 because the pensions are now taken into account. Look at Hussein. Everything's exactly the same, except now we take into account his pension of £100,000. That brings his estate up from 650 to 750. 750 minus £325,000 leaves us with £425,000, which now means an inheritance tax liability of £170,000 on his estate. What was it before? 130. Now, 100,000 pension, 40% on that, £40,000 more in tax. Do you see how that is going to change? I had one client who, young individual, he was a senior official at one of the big banks. He has a death in service benefit of 20 times his salary, so it's due to pay out about 2 million or so on his death. If he dies, and he's a young chap, may Allah subhanahu wa ta'ala give him a long life, inshallah. But I had to illustrate this to him, that if you die before April 2027, that £200,000, that £2 million, no tax on it. But if you die after, 40% on 2 million. Still, the tax is still payable, right? So do you see how drastic this can be for a lot of people? Because up until now, pensions have historically been a tool where people put assets into to save tax. But that's all now changing from April 2027. Have these examples made sense? Okay. So now we build it up, okay? So inheritance tax planning essentially involves reducing your estate in your lifetime mainly by making gifts, by gifting your estate to family members during your lifetime. Any gift that you make in your lifetime, and again we're getting technical here, any gift that you make in your lifetime is called a potentially exempt transfer or a pet. Okay, not the cat or the goldfish you have at home, but a potentially exempt transfer. Why is it called a potentially exempt transfer? Because if you live 7 years from the making of the gift, it will become exempt. But if you die within 7 years of making the gift is still treated as part of your estate. Everybody knows this principle, yeah? I'm not going to worry about the third bullet point to trusts, we don't have time. A pet, a gift in your lifetime, uses up your £325,000 allowance. But it refreshes if you survive 7 years. I'll give you an example here. We have an individual named Qasim who is married to Zainab. And you know, the funny thing is, whenever I give these examples, people are always trying to work out who these people are. These are all fictitious people. They don't exist in real life, okay? Yeah, they're all fictitious people. Okay, so we have Qasim who is married to Zainab. He has one son by the name of Bilal. Bilal is getting married. So Qasim does what any parent would like to do on the occasion of the marriage of his son. He makes him a gift of £50,000 to help him maybe towards buying a new house with his spouse. And he makes that gift today, 26th of April, 2025. What is the effect of that gift if A, Qasim dies in May 2032? And what is the effect of that gift if he dies in May 2027? So the first example, if Qasim makes a gift today, 26th of April, 2025, and he dies in May 2032, how long has he lived? More than 7 years. Yeah? So that gift is now outside of his estate. His £325,000 allowance is refreshed. But if Qasim dies in May 2027, let's say he survives only 2 years. He survives only 2 years. His £325,000 allowance is reduced by the value of that gift of £50,000. So his £325,000 allowance now goes down to £275,000. So now, instead of his estate benefiting from £325,000 allowance, it only benefits from a £275,000 allowance. Now, if you go to a proper solicitor or a tax advisor, they will tell you that you can reduce the value of that gift of £50,000 by £22,000. I'm not going to tell you how, because that's giving away secrets of the trade. But this is the basic principle. Do you understand? That if you make a gift and you don't survive 7 years, the value of that gift eats into the allowance that is then available to offset against your estate at the time of your death. I'm not going to talk about taper relief, we don't have time, but one thing that I will mention here. Bilal, the son who has received a gift, he also has to think about a few things. He's received a large sum from his parents. Now, I know I keep harping on about divorce, but unfortunately it's a reality of our communities. It happens very common. How does he protect that £50,000 in the event of his divorce? So that is something that Bilal will also need to consider. Do his parents lend him the money? Do they put a charge on the house? What do they do? Do they enter into a prenuptial agreement? All of these situations and scenarios we would discuss with Bilal. But that is just something to take away, that when you are making large gifts to your children, it's not just about you reducing your estate so you pay less tax. It's also about them using that wealth properly and protecting it properly for the benefit of your family going forward. So there's always two things to consider. It's not always just tax. There are certain gifts that are exempt that do not use up that £325,000. So remember I said, Qasim made that gift of £50,000, he died within 7 years, so his £325,000 was used up by the amount of that gift. There are certain gifts that you can make in your lifetime that do not use up that allowance. So even if you die within 7 years, your allowance still remains at £325,000. Is everybody with me? So any gift you make to your spouse, your legal spouse, and again I stress this, legal spouse, because I will often have families coming to me who call themselves married because in the eyes of Allah they are married. But when you ask about the legal marriage hasn't taken place. So a gift to a legal spouse is free of inheritance tax and is exempt from inheritance tax and does not use up that £325,000 allowance. So again, one of the sisters raised it, and I'll mention the point here about, you know how I said earlier in a joint tenancy, if a husband dies and the wife gets the property, she has already potentially received more than the share that she's entitled to under Sharia. One option is for the husband to maybe gift the property to his wife in his lifetime. So she is now the owner of the house. I know the ladies will be very happy to hear this, but you again also need to think of other considerations. What if you divorce later on down the line? So that's not always a solution. Okay, but just hypothetically here, any gift that you make to a legal spouse is exempt. Number two, any gift that you make to a registered UK charity is also exempt. So any donation you make to the Salam Center or to any other organization that is registered as a charity under the laws of this land is exempt. And I have had, alhamdulillah, many clients who have been in the position of significant wealth. And as you know, although there is an emphasis on charitable giving in the will, charity has more benefit for us in the eyes of Allah subhanahu wa ta'ala if it is done in our lifetime. So I have many clients who, alhamdulillah, have been in positions where they have been able to gift properties to organizations like the World Federation or to other Islamic organizations in order that the organization then benefits from that asset. So if somebody is in a position to be able to make extensive gifts like that, all well and good. But if you are not, any small amount, whatever it is, any donation that you make to charity in your lifetime, to a UK registered charity in your lifetime, is exempt from UK inheritance tax and does not eat up that £325,000 allowance. I'm not going to worry about number three. Number four, any gift that you make on marriage to a child. So that £50,000 gift that Qasim made to his son Bilal, of that, he would have got a marriage exemption of £5,000, because any gift that you make to your child on the occasion of their marriage is exempt from inheritance tax up to £5,000. Okay? If a grandparent makes a gift to a grandchild who's getting married, the grandparent gets an exemption of £2,500. And if I make a gift to anybody who is unconnected with me, I can get an exemption of £1,000. Okay, so if you go to a random so-and-so's wedding tomorrow, you can give up to £1,000 to them free of tax. Okay? Number 5 is important. Annual exemption, £3,000. Every single individual can make a gift of £3,000 in any tax year. Remember, the tax year goes from April to April, to anyone they want without that £3,000 eating into that 325,000 allowance. And if you have not used your annual exemption from the previous tax year, you can carry it forward by 1 year. So let's say, again, going back to Qasim, okay? He made a gift of £50,000 to Bilal. £5,000 of that is exempt because it's a marriage exemption. £3,000 is exempt because it falls within his annual allowance for that year. He hasn't used it for the previous year, so that's carried over as well. So all in all, of that £50,000 gift, 11,000 is exempt. Do you see? Now, if that gift had been made from a joint account by Qasim and his wife Zainab, then you would have got Zainab's allowances as well. So that gift would be reduced by 22,000. So again, it's just simple structuring like this that can help you make the best of the gifting and the tax consequences that follow. I'm not going to worry about number 6 because we don't have time. But one thing that I will say is that if you make any gifts to anybody, always keep a record of them. And by record, I mean the date that you made the gift, the name of the recipient, and the purpose. And Shaykh Imranali alluded to this when he mentioned that he acted as executor. He had to go through bank statements. One of the reasons that you would have to go through the bank statements of a deceased person is that you have to account to the Inland Revenue for any gifts that person made in the 7 years prior to their death, because the revenue needs to know if that allowance has been used up or not. Now, if I have made a record of that, I make the life of my executors very easy, because they don't then have to spend all of that time going through those bank statements. But if you haven't made that record, when it comes to dealing with the practicality of that administration, I can tell you, it gets very expensive when you have to pay me to go through your bank statements for 7 years. So the more groundwork that you have done in your lifetime to prepare for these things, as Shaykh Imranali said, to keep a file of your assets, of your liabilities, it all helps to smooth out this process when you die. Everybody with me so far on how you can make certain gifts that do not use up that £325,000 allowance? Everybody with me? Yeah? Now, what things can I do apart from making gifts within those exemptions that can reduce my value for inheritance tax? I'm only going to go through some of these on this slide here. A lot of people will come to me and say that I want to gift my family home to my son. Traditionally, we still have this setup where a certain son and daughter-in-law may live with parents after they get married. And the father will have been talking to somebody at the masjid and will have been told that if you gift your house to your son and you live for 7 years, then the house is out of your estate and it's not taxed anymore. That's incorrect. Because if you make a gift of your house to your son and you continue to live in that house and you continue to benefit from that house, the Inland Revenue will say at the time of your death that although you're no longer legally the owner of this house, you're still enjoying and benefiting from it. So therefore, we are going to tax you on it. So giving your house or your asset away and still benefiting from it doesn't work. There are ways to make this work, but I don't have time to go into that now. But the basic principle is that if you give an asset to somebody, whatever it may be, if you give a rental property to your son, but you say, okay, beta, the rental property is yours, but I'm going to get the income, and I'll pay the tax on the income, but the income's going to come to me because I still need it to live, that doesn't work because you're benefiting from that property. So the revenue will say it doesn't matter if you don't legally own it anymore, you're still benefiting from it, you're enjoying it, and therefore we are going to tax you on it as if it still belongs to you. Okay, so that's a very common misconception that people have. That if you're living in a property with your child, you can just give it to them, live 7 years, and then that property is no longer part of your estate. That's incorrect. Okay? Insurance policies. Okay? I alluded to this earlier, that particularly for younger couples whose estates are above these thresholds of £325,000, you may consider taking out life insurance whilst it's cheap for you, whilst you're younger and in good health, to provide a pot for your family to be able to pay that inheritance tax so they then don't have to sell off the assets of the estate. Yeah, you all know how insurance works, right? Trust planning, again, I'm not going to go into this, we don't have time. But one thing that I do want to mention here is family businesses. Alhamdulillah, we're a very entrepreneurial community, right? We have people here running businesses of all sorts. Opticians, dentists, pharmacists, we all have our trading businesses, whatever it may be. Up until next April, if you have a business, and that business can be run in any form, so you can run it as a sole trader, you can run it as a partnership with someone, or you can be a limited company, okay? As long as you have a trading business and by the time that you die, you've had that business for at least 2 years, the current rule is the entire value of that business is completely exempt from inheritance tax. So let's say I have a £2 million business, whatever it may be. Let's say I'm selling, I don't know, fruit and veg, okay? And I have a company that's selling fruit and veg and it's worth 2 million. Currently, when I die, that entire £2 million business is exempt from inheritance tax, completely. However, from next April 2026, the rules are changing. That of your business assets, instead of being fully exempt, only the first £1 million is exempt. So of my fruit and veg business, so right now my fruit and veg business could be worth £10 million and my estate would not pay a penny of tax on it. But next year, let's say it's worth 10 million, only the first 1 million is exempt. The remaining 9 million will be taxed at 20%.
Does that include sole trader, limited?
Correct.
So it includes
as long
all,
as it's a trading business.
So it can include a sole
Correct.
trader.
Correct.
And just a second point, just to benefit the audience, is that so whatever income I may earn in that year, and I record that the invoice and the income, that will not be subject to inheritance tax.
No. So so there's a distinction here. Yeah, the value of what it's worth. So the income that you're recording and reporting, that's your income tax liability in your lifetime that you're paying income tax on. You now die.
Yes.
Yeah. The value, the business has to be valued for inheritance tax purposes because all of the assets of the estate have to be valued.
Yes.
The business is valued. Currently, it's worth 10 million. Okay. At this point in time, you would put on the inheritance tax form value of business £10 million reduced by the relief, 0. So tax liability on that business is 0. But as of April next year, it would be value of business £10 million, relief £1 million, taxable £9 million.
So this even applies as a sole trader?
Correct, correct.
Okay.
Correct.
No problem.
Sole trader, partnership, limited company. Okay? So it only applies to trading companies. But for those of you that have businesses in the room, whatever they may be, this is something that you will really need to look at in the next few months. Because you will need to most likely amend your wills, you will most likely need to amend your tax planning in order to take account of this. You can see how big a hit this is going to be for people that have businesses. Yeah? We're encouraged within Islam to have this self-sufficiency, right? To not be dependent upon other people. So it's a good thing that we are a community of entrepreneurs, that we are able to sustain ourselves, that we are able to create longevity. But now this is something that has been attacked in the current budget. And there was a lot of commentary that this was introduced last October, when the autumn statement was published by the Chancellor. This was introduced and it caused uproar. You can see why this has been a momentous budget for us, because up until now I had clients who were running businesses worth hundreds and millions of pounds that we didn't need to worry about at all because there was no tax on them. Now all of a sudden, from April next year, there's going to be a huge liability on their tax, on their businesses. Issues of how is that business now going to continue? How is that tax going to be paid? What assets will need to be sold to pay that tax on that business? Will their employees will they still be able to keep their employees? And that is a big concern for employers, people who have people working under them. They feel a sense of responsibility to their employees. Now, how do we look after these people whose livelihood depends upon us if we now have to sell parts of our business to pay this tax? So this is huge. So for those of you that have got businesses in the room, this is something you really need to look at before next year hits, before next April hits. And 2 final points on this slide. Always seek financial and legal advice before you make a substantial gift. Because you need to understand that if I make a gift of X amount to my son, or if I make a gift of this property to a charity, or this property to my son, or this property to my daughter, you need to understand the tax implications of that gift. All too often, people will make the gift and then come to see me, and then I have to try and repair things, and that becomes difficult. It's much easier to start off with a clean slate when you come to me and say, I want to do X, and I can help you structure it in the right way. The final point on that slide is, although we all want to avoid inheritance tax in a legal way by giving away our assets in our lifetime, we also have to be practical. We cannot depend upon our children to care for us in the future. Okay? I have seen clients who have been suffering from things like advanced dementia, advanced Parkinson's, advanced Alzheimer's, who would like to be cared for at home, but their situation is such that they cannot be cared for at home because it's too much of a burden on their families. Or they are a danger to themselves. I had one lady many years back who was paranoid that people around her were going to attack her, so she would walk around the house with a knife. It sounds funny, but that person cannot be kept in the house. She's a danger to herself and to the people around her. She has to be moved to a safe facility. And that facility costs. So we all have to think about provision for future care. I want to give away my assets in my lifetime so my children don't pay too much tax, but am I shooting myself in the foot by giving away too much and making sure that I don't have enough to look after myself? Yeah, it's a really important thing. And I refer you to the Holy Quran, Surah number 17, verse 29, in which Allah subhanahu wa ta'ala says, do not be so tight-fisted, maghlul. Do not be so tight-fisted, for you will be blameworthy. But do not be so open-handed, for you will end up in poverty. So many times you will have heard off the manabir, the Shaykh saying, give away everything in your lifetime. We've heard that. I don't know, no reflection on Shaykh Imran, but you've not said that. But I've heard shuyukh saying this off the manabir, and I just sit there with my head in my hands thinking, this is completely the wrong advice, because you need to make sure that you're looked after. Right? I want to stop my children paying tax, but then I'm shooting myself in the foot by not making sure that I have enough to look after myself. I cannot guarantee that my son or my daughter will look after me. Yes, everybody has best intentions, but if I make them a large gift, they may invest it in a property, they may invest it into something else, which means that when I need that money back, they may not be able to give it to me, despite how much they may want to. So I have to be sensible about how much I give away. Okay, so there's always this balance to be struck between paying less tax and looking after myself. Yeah? So, let's explain how these inheritance tax allowances work. Okay? So the first example that I want to, or the first exemption I want to mention, which I have alluded to, is the charity exemption. I've told you that any gift that you make to a UK registered charity is free of inheritance tax. You can give as much as you want to charity. It does not impact upon your £325,000 allowance. After death. No, even in lifetime. Even in lifetime, if you make a gift to charity, it reduces your estate and it leaves your 325 intact. Yeah? On death, however, if I make a gift of at least 10% of my estate to a registered charity, okay, the remaining 90% of my estate is still subject to inheritance tax, but the tax rate goes down from 40% to 36%. So it's not much of a saving, but it's still a saving. It was introduced in 2012 to encourage people to give more money to charity. So I have a lot of clients who want to make use of that. Now that really is only useful in estates where you have a lot of cash. It's not very helpful in estates where you have property, because a charity will not want property, they will want cash usually, and you will have to sell assets in order to pay that charity their 10% share. So that may or may not be desirable, but you would look at that for a client and see, does this work in that scenario? But it's something to be aware of, that if you give at least 10% of your estate to a charity, the remaining estate is still taxed, but it benefits from a lower tax rate.
So it's 10% or more?
10% or more, yeah. Now we come to the more important exemption, which is the spouse exemption. Okay, so any gift that you make to your legal spouse whether in your lifetime or on your death, is exempt from inheritance tax. The spouse who dies first, if their £325,000 allowance has not been used up by gifts in their lifetime, that can be carried over to their second spouse. So I'll give you an example here. Okay, we have Ali and Fatima, and again, these are fictitious people. Okay, so Ali dies in December 2024, and he leaves his estate of £650,000 to his wife Fatima. Okay, here we're not dealing with the issues of the Sharia at all. Okay, I'm deliberately not dealing with Sharia issues here. I'll explain how that interacts in a few moments. So Ali, he dies in December 2024, and under his will, everything goes to his wife Fatima. Okay, Ali has not made any gifts in the 7 years prior to his death, so his £325,000 allowance is intact and unused. When Fatima dies a few years later on, let's just assume that her estate is also worth £650,000. Fatima has also not made any gifts before she dies, so her allowance is also intact. So Fatima has now died, her estate is worth £650,000. Her estate benefits from her £325,000 and Ali's £325,000. Even though he died many years before, it can be carried over to Fatima. So that means her estate is reduced by 2 lots of £325,000, which means the IHT liability is 0 because the entire estate is within that exemption amount. Everybody with me?
So at this point, this only transfers upon death.
On death.
Yeah,
Only transfers
it's not
upon
like
death. Not
the
in
normal
lifetime.
tax to transfer your
No.
tax band. Yes.
No, does not, no, that's income tax.
Yes,
Yeah, yeah.
yes.
So, what would have happened if a spouse had made a gift in their lifetime but didn't survive the 7 years? So remember that example I gave of Qasim and Zainab? Qasim gives 50,000 to Bilal. Okay, so Qasim dies in May 2027. So he dies within the 7-year period of making a gift to his son. His estate is worth £500,000 and he leaves his entire estate to his wife Zainab under the terms of his will. Now, as we know, when he died, before he died, in the 7 years before he died, he made a gift of 50,000 to Bilal. When Qasim dies, because everything goes to Zainab and she's a legal spouse, there's no tax to pay. But Qasim's allowance has been reduced from £325,000 to £275,000 by the 50,000 gift that he made. So what that means is when Zainab dies, her estate is worth 650,000. She gets her full £325,000 because she doesn't make any gifts. But Qasim, only 275,000 is transferred over. So even though that estate is within the 650 bracket, the gift that he has made in his lifetime has used up some of his allowance, which means that not the whole allowance is available to offset or to transfer across to Zainab. So the value of the estate is 650. We get Zainab's 325,000, but we only get 275 from Qasim. So that leaves £50,000 exposed. So that means tax on £50,000 of 40%, which gives us a tax bill of £20,000. Does everybody understanding how this works? Yeah? Okay, let's add another layer because it gets more complicated. You're all with me so far? Okay. Now, in 2017, the government introduced another allowance called the residence allowance. Yep. The residence allowance applies where you leave your main home to a child or to a lineal descendant. So this only benefits people who have children. If you don't have children, you don't get the additional allowance. Okay? Any age. The tax-free residence allowance applies where you leave your property to a child or any other lineal descendant. So it can include grandchildren. It can even include the spouses of your children and grandchildren, and stepchildren, foster children, adopted children as well. So the class is quite broad, but it has to be descendants. Okay? And when I say adopted children, I mean formally, legally adopted children. Okay? The residence allowance is currently £175,000. So an individual who has a property and who has children will have their normal £325,000 allowance and a £175,000 residence allowance. So when we add that together, that makes £500,000. So if you have a situation where husband has 500,000, wife has 500,000. Between them, a married couple can have up to £1 million worth of allowances before any tax is due. But if your estate is worth more than 2 million, and as I said, estate will include everything that you own, including property abroad, including your businesses, including your properties, shares, whatever it may be. If your estate is above £2 million, you start to lose the £175,000 allowance. So the 2 million, somebody asked me at the beginning, I don't know if he's still here, that is there a sweet spot for inheritance tax planning? Yeah. The sweet spot is if you're 2 million or below. There's a lot you can do. When you start going above 2 million, you start losing some of the allowances and having to pay more tax. Right? So if your estate is above 2 million, you will generally not benefit, or benefit from it in a limited way, because I don't have time to explain how the tapers work. But you will benefit in a limited way only from that. And I'll illustrate through an example. So again, Hassan and Sakina. Hassan died in 2015. Are these case studies helpful? Yeah? So Hassan died in 2015, and his estate was worth £1 million. And he left everything, including their house, to his wife Sakina. He had made no gifts in the 7 years prior to his death, which means his 325,000 allowance was intact. Okay? Now on Hassan's death, because everything goes to his wife, his legal wife, there's no tax to pay. No inheritance tax. However, when Sakina dies 9 years, 10 years later, let's assume that through inflation, the value of the estate has now increased from 1 million to 1.5 million. Under her will, she leaves everything to her children. So what is the tax position of Sakina's estate now that she has passed away? So the estate is worth 1.5 million. She has her 325,000. She has her residence, 175,000. She can, or her estate can transfer over Hassan's 325,000 and Hassan's 175,000 allowance. So that means we get a £1 million allowance. So 1.5 million, deduct 1 million, that leaves £500,000 exposed to tax, £500,000 taxed at 40%, there's still a tax bill of £200,000. Yeah. Possibly, yeah. Depending on what's in the estate. So, but 200,000 sounds like a big number, but when you look at it, 1.5 million less 200,000, there's still 1.3 million for the kids. So they haven't done too badly out of it. Okay? It's still a lot of money. It's still a lot of money, but the kids are still not doing entirely badly out of it. Okay? That's how that works. I'll just give you, just to explain how this works when your estate is above 2 million. So you've got Ahmad and Amina. Ahmad dies in 2015. His estate is worth 2.5 million. He leaves everything to Amina. No inheritance tax because everything goes to a legal spouse. And he's made no gifts, so that 325,000 is intact. By the time Amina dies, 9-10 years later, the estate is now worth 2.8 million. Her estate is worth 2.8 million. It's above the threshold for the residence allowance, so the 175 doesn't apply to her anymore, and she can't even transfer over Ahmad's 175 anymore. All they are limited to is each other's £325,000. So on an estate of 2.8 million, you only get Amina's 325 and Ahmad's 325, which gives you a taxable estate of 2.15 million. Tax at 40% on that is 860,000. Yeah? So the children still get 1.94 million after I'm trying to show you the bright side here. Yeah? The children still get 1.94 million, but there is still a lot of money that has gone in tax. Now that could have been reduced by gifting and trusts and all these other things that they may have been able to do in their lifetime. This is the typical scenario of a family who hasn't taken any advice. Okay, typical scenario. Has that all made sense? So just a recap of the allowances. A single individual with no children, £325,000 allowance. Single person with children and property, 500,000 because you get the 325 and the 175 residence. Married couple with no children, 650 because the 175 only applies where your property goes to children. Married with children and property, which is the typical scenario for most of the people in our communities, £1 million, but only if the estate is worth 2 million or less. Now, normally, if I have a client who comes to me with an estate of, let's say, 2.3 million, one of the first things we'll say to them is, let's gift you enough to get you to 2 million. Because if we give away enough in your lifetime, we bring the additional allowances back into play. Okay? So, has that all made sense? In order for these, but these allowances, remember, they're not automatic. Your wills have to be drafted properly to capture these allowances. If you die without a will, then remember what we said in the previous slide, some goes to the children, some goes to the spouse. The wills have to be drafted properly to make sure these allowances are all captured. Okay? Now, this is where I want to show the interaction between the Sharia and the practicalities of the law of the land. And I'm assuming that we have Muhammad and Khadija here, and Muhammad has used one of these template wills, which I have such a fear of people using, because again, being very honest, the most expensive estates that I have administered over the years have been the ones where people have done DIY jobs or used templates. They have been simple estates, a house, property, not much. But because they have used template wills that don't take account of these tax allowances, they have created tax liabilities that would otherwise not have existed. I have one family who, by doing things improperly, created a £90,000 tax liability when it would have been zero. Right? So this is a salutary reminder of, if you don't do things properly, you can create liabilities as opposed to avoiding them legally. Okay? So Muhammad dies, leaving behind an estate of £1 million. He leaves behind a wife, Khadija, and his parents, but he has no children. So the first thing we have to understand is that that 175,000 allowance is not available to him. Okay? He writes a Sharia-compliant will because he's attended a seminar like this and he's taken something away, but he's only got half the story. Okay? He fell asleep in the second part. Okay? So he writes a Sharia-compliant will in which he gives a quarter to Khadija and the balance goes to his parents, a third to the mother and the rest to the father. That is a Sharia distribution. But what is the practical effect of that will on a £1 million estate? Khadija gets £250,000, which is a quarter. Anything she gets, there's no tax to pay because she is a spouse. The balance of the estate, which goes to the parents, which is worth £750,000, there is inheritance tax to pay on that. And the amount of tax to pay on that is £170,000. So of that £750,000, the parents end up with £580,000. Now you have a situation where, of a £1 million estate, Khadija gets £250,000, Muhammad's parents gets £580,000, and the treasury, the revenue, get £170,000. That is the effect of a pure Sharia-compliant will. Okay, he's done everything in the eyes of Allah subhanahu wa ta'ala. But his family faces this liability and they face this division problem. What are the issues with this? The first issue is the needs of the parents versus the needs of the spouse. The spouse has ended up with £250,000 and the parents, who may be elderly, have ended up with £580,000. There's a complete disparity there. You know, what if Khadija has been a housewife her entire life, who now has no earning capacity or potential to go out and sustain herself? Is that £250,000 really sufficient to sustain her? What if that £1 million estate consists mainly of property? It's not uncommon in our communities for people to be what we call asset rich and cash poor, where the majority of your money and your wealth is tied up in assets. So if the majority of that 1 million is tied up in property, you're going to have to sell some of the property, or you're going to have to sell the property to pay that tax and to give everybody their share, because where's that tax going to then come? Where's it going to come from? The next question is that if everything has to be sold to pay that £170,000 liability, is that £250,000 that Khadija gets sufficient to rehouse her and provide her with an income for the rest of her life? No. And lastly, you remember how I said, like that Sikh lady who had a claim against her husband's will? Khadija, being hopefully a God-fearing woman, would not bring such a claim, but that doesn't mean that she doesn't have one under English law. So what sort of solutions can we present to this problem? Muhammad could give that additional 1/3 that we talked about to Khadija. So that would increase her share to over 500,000. But the bit that the parents get would still be subject to tax. And there would still be a tax liability of just under £40,000. Okay? That could be satisfied through life insurance if Muhammad had taken out life insurance to pay it. But one sort of rule that we look back into is Sayyid Sistani's Tawdih al-Masail, rule number 2738, in which the Sayyid makes very clear that if you try and dispose of your estate that is more than the 1/3, as long as you gain the consent of your heirs to what you are doing, you are generally permitted to do that. Now, what Sayyid says is that the consent you have to get from your beneficiaries is 2-tier. So Muhammad has to get 2 types of consent. He has to get consent from his parents that, Mom and Dad, I'm not going to leave you everything, I'm going to give it to Khadija, because anything I give to Khadija, there's no tax to pay. So his parents first have to agree that they will not take their share, and then they have to also agree who that share goes to. So they have to agree that we parents will not take anything, and we agree that what we would have otherwise got now goes to Khadija. It's not enough for the parents to say, we're not taking our share. They have to agree to who their share goes to. So this tends to be the, I think we used the word yesterday, loophole, that we use to get out of this Sharia problem that we have. That as long as you can get the consent of your heirs, so in this situation, if Muhammad is saying to his parents, look, Mom and Dad, you're well settled. You don't need £580,000 from my estate, but Khadija needs this to live on and sustain herself for the rest of her life. If he's had these discussions and he has obtained that consent from his parents in lifetime, then he has the freedom to do what he wants in his will. Do you see? If Muhammad had not had those discussions, legally, between them, Islamically and legally, the heirs can agree after he has died to redistribute the estate. So the parents can say that, look, we will give more from our share to Khadija in order to sustain her. And legally that document has to be entered into within 2 years of death. Because remember, anything that now goes to Khadija is now free of tax, so the tax liability drops. Do you see? Just another illustration. Same scenario, but in this time, Muhammad has children. Okay, so he has Khadija, his parents, and he has 2 children, a boy and a girl. Estate is still worth $1 million. He writes a Sharia compliant will. 1/8 to Khadija, the parents get 1/6 each, the rest goes to the children. In that scenario, Khadija now gets even less. She gets 125,000. The balance, there is tax to pay of 150,000. So of that division, 125 goes to Khadija, 150,000 goes to HMRC, and between them, the parents and the children get £725,000. That's the practical effect of that will. Again, same problems. Needs of the parent versus the needs of the spouse. What if these children are minors? What if they're under 18 and they can't look after this 600, 500,000 pounds that they now inherit? It goes on a trust for them, but Khadija can't manage that trust. She can't sell anything that's in the trust for the kids. Again, asset rich, cash poor. You have to sell assets to give everybody their share. So again, we come to the same problem. And again, the solutions are, we could give Khadija more from a 1/3 share, or we could look to life insurance, or we could look to getting the consent of the family. Now, the problem here with getting consent is you may have children who are nabaligh, who are not able to legally, Islamically give that consent or understand the ability or the concept of that consent. And that's where we run into problems with even this loophole that Sayyid has given us. And now there's no easy solution to this. And that's where sometimes when I'm having these discussions with my clients, I said to Shaykh yesterday that my job is, when a client comes to me, my job is to give them a recommendation, to say you should do X, Y, or Z. But with my Muslim clients, I can't give you a recommendation. I can only give you options and say, if you go down the Sharia route, this is the issue. If you go down the non-Sharia route, this is the issue. If you go down the middle route, this is the issue. Now, which one do you want? And I don't make a recommendation because that's between you and Allah, and I can't come into the middle of that relationship. So with a non-Muslim client, I will make a recommendation and say, you choose this option because you pay less tax on it. But with a Muslim client, the situation is different. The tax still has to be paid, but you also have to be mindful of your obligations. So I said this to Shaykh Imran yesterday. I can only give you options and say option A is this, option B is this, option C is this. Now which one works for you? And you have to tell me and I can then put it on paper. So Sayyid Sistani has given us this ability, but it's limited in its application. Because what if I have nabaligh children? What if I have a beneficiary who is disabled or unable to give that consent? Right? What do I then do? And then you have to take a view. And then it's between you and Allah. I'm not the haram police. I can't sit there and say to you, this is good for you, this is not good for you. It's between you and Allah. I can't interfere in the middle of that relationship. I can guide you to a degree. I can put you in touch with scholars who can help you. But ultimately the decision is then remains to be justified between you and Allah. So just to recap, there is a direct conflict between the proportions that the Sharia sets down and the tax system of this country. And that is because, as I said at the beginning, we are living in a man-made system and we are trying to put a divine system within that. A divine, perfect system. We're trying to put that and mold it into a man-made system, and it doesn't work. So a strict compliance with the Sharia is not necessarily tax efficient. Issues arise with regards to the maintenance of the spouse, especially a female who is financially dependent upon the husband. The precise requirements of the Sharia and the tax may require a sale of the assets of the estate. Now, again, it comes back to that same issue. If you're selling the property to pay the tax, where's Khadija going to live? It's that simple. Where's she going to live? Right? She then becomes a burden upon society. Okay? Giving away in your lifetime, although it is a form of tax planning, it's not always desirable. Every time you give an asset away, you're not just thinking about inheritance tax. You have to think about capital gains tax. You have to think about stamp duty. You have to think about income tax. You have to think about the basic fact, are my children mature enough at this age to receive those assets? What if my children are in an unstable marriage and they are on the brink of divorce? If I give them assets now and they get divorced, will those assets then now potentially go to their ex-spouse? So giving away in my lifetime is always also not desirable. And if I don't have these conversations and understandings with my family beforehand, and it's exactly what Shaykh Imran said, and I couldn't endorse it more, that there is a high recommendation from, I guess, both of us to have these discussions with your family in your lifetime as to what the intentions and the expectations and the practicalities are. Okay? Rule 2738 of Sayyid Sistani gives us a limited way out, but it doesn't apply in every single scenario. Yeah? If you have a married couple with adult children, yes, it can work if everybody is in agreement. In my 15 years of practice, I have probably only ever come across a situation once or twice where a child has refused to give consent. And in both cases, the parents disregarded it and did what they wanted anyway. Now that's between them and Allah. But most children living in this day and age will look at their parents and they will say, whatever you have worked for is for you, therefore it should be available for you. And I will defer my haqq until you have both died. I will not insist upon my haqq on the death of one parent, because I know that will put the other parent into difficulty. That tends to be the approach that a lot of youth today take, but not everybody. So it's important that you have those discussions with people. When do you need to seek professional advice, particularly with regards to tax? Where you've got assets or connections to a foreign country. Remember I said, if you're living in the UK, your assets abroad are also taxed here. Marriage, divorce, remarriage, okay? If you get divorced, if you get remarried and you have children from a previous relationship, you need to think about what happens on your death. How do I make sure my new spouse is looked after and provided for, but also ultimately that my assets go back to the children of my first marriage, because they are ultimately the heirs. How do I ensure that to happen? What if you have children from different marriages? Marriage 1 gives you 2 children, marriage 2 gives you 2 children. Yeah? How do I balance both families? Even now, more importantly, business assets, including, as I've said, sole traders, partnerships, family companies. Important now, in light of the rule change coming in next year, where only £1 million worth of business assets will be exempt and everything else will be taxed. Okay, what if I have a disabled child? I need to provide for that child maybe more than I have to for my current other children, because they will need care and support for the rest of their life. What if I have care needs. What if I need to fund care costs? Again, basic example, and the medical practitioners in this room will be able to give more insight into this. But in South London, where I'm from, the cost of a good care facility is costing anywhere between 80 and 100,000 pounds a year. Yeah. Right? I need to be able to provide for that if I have to face a situation in my life later on where I might need care. Okay? What to do when somebody dies, practicalities. I will just touch on one point here. I know we're running. Yeah, sorry, we're running away with time. One thing about inheritance tax when somebody dies, the general position is that inheritance tax has to be paid within 6 months of death. Now that does not give a family enough time sometimes to raise the cash. So inheritance tax on illiquid assets like company shares, private company shares, or property can be paid over a 10-year period. You have to make an election in the death tax return to pay the tax over a 10-year period with interest. Yeah, if you don't pay the tax on time, interest is running. Yeah, so if you don't pay the full tax within 6 months, interest is currently 8%. It went up on the 6th of April. Yeah. So that's just something to be aware of. Just final wrapping up, some points to take away. Most people will generally require professional advice. It incurs a cost, but it's worth it. Okay, you are protecting your entire life's hard work, and you want to make it pass down in a way that is efficient. As I've said, beware of the dangers of using will templates, like the Muhammad and Khadija scenario. They usually only cater for the Sharia elements, and as Shaykh said in his disclaimer, not for the legal and tax side of things. So beware of that, okay? Use appropriately qualified professionals. I cannot stress this enough. People will go to any solicitor or any accountant and think that they can help them with this. Okay, it's like me going with a heart condition, going to a neurosurgeon. He's going to say to me, go to the cardiac surgeon, because he will tell you about the heart. Come to me if you have a brain issue. Okay, not every solicitor is qualified to deal with this in the same way that not every doctor is qualified to deal with every issue. Do your research. Choose people that are appropriately qualified and that have the recommendations. STEP, STEP, Society of Trust and Estate Practitioners, is a worldwide recognized qualification. It has millions of members across the world that have set additional professional exams in this particular field. When you're looking for somebody to help you with this, go onto their website and look and see and search for appropriate professionals. And the last one is use somebody who is regulated by a professional body. The SRAs, the Solicitors Regulation Authority, ACCA, ICAEW, accountants who are also authorized to carry out these services. Use someone who is regulated, because if something goes wrong, you have a right of recourse. If you use somebody who is unregulated, and I will give you an example. This family I told you, where the will was not done properly, that created a £90,000 tax liability, that was written by an unregulated will writer. In a normal situation, you would have been able to sue them and recover that 90,000 back, but because they were unregulated, they disappeared and we could not find them. If that will had been written by a solicitor who is regulated but made a mistake, and that tax liability still arose, you would have been able to sue that solicitor and their firm and get their money back. That's the difference. So use somebody who is regulated. And that's the reason why professionals charge, because we have to pay for the insurance if something goes wrong. Right? But I cannot stress on how important it is to use somebody who is regulated, because even if you come to me and I make a mistake, which is perfectly possible, you still have a right of recourse against me. That if you end up paying more tax than you should, my firm will pay out to you. Right? That's how simple it is. Do not assume that your family are aware of your intentions. Involve them in your discussions. And lastly, I want to end with this point. Our aim is to leave behind khair, to leave behind goodness. The impact that our will has, if it causes disputes, if it is unclear, will have an impact upon me 6 feet under. And what I will always say is, remember the dua of Nabi Ibrahim alayhi salam in Surah Al-Anbiya, verse number 84. وَاجْعَلْ لِي لِسَانَ صِدْقٍ فِي الْآخِرِينَ. Loose translation that appears is that, oh Allah, allow me to be remembered honorably amongst future generations. Yeah, that's what we want, to leave behind this legacy of honor and izzah and karama behind. To not leave behind a mess that when our family look at our will, they say, ah, Papa did this or Mom did this. It's to leave behind khair, to leave behind goodness, to allow your estate to be wrapped up quickly and promptly so that the assets go to the heirs who can then use them properly for your benefit. You leave a mess behind, it will impact us 6 feet under. Because we know that every action that we do in this dunya will translate itself into the afterlife, and it will manifest itself even greater. It will be amplified in the akhirah even more. So to leave behind goodness, to leave behind things in good order, so that my family know what they're doing. And that everybody has been catered for, and that if I am doing something that is in contravention to the Sharia, I have gained the requisite consent, I have had the discussions, I have had the conversations that I need to have to be able to close my eyes peacefully and say, Ya Allah, now it's in your hands. And I think we will stop there. وآخر دعوانا الحمد لله رب العالمين والسلام عليكم جميعا ورحمة الله وبركاته.
I just want to say thank you so much to both of our speakers. You know, I personally have found it very insightful, and I'm really grateful to both of you for taking the time to come and speak to us and give us the different perspectives, so everyone can kind of think about their kind of worlds and how they take that forward.